And Your Honor, we have Mark Umphris, also on page 1.
Mark Umphris. All right, this is cause number CR 21-0365-173, the state of Texas versus Mark Umphris, set for arraignment. Mr. Castleberry.
Thank you, Judge. Your Honor, we have received a copy of the indictment with waive reading. His name is spelled correctly. He understands what he's charged with, the range of punishment, and for the purposes of arraignment this morning, we're going to plead not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That is August the 11th at 9 a.m. for discovery status, and on September 8th at 9 a.m. for pretrial. And so if you get out of jail between now and August the 11th, I need to see you here at 9 a.m. All right, you can have a seat.
On page 2, Judge, I have Tyler Winterton.
Tyler Winterton. This is cause number CR 21-0456-173, the state of Texas versus Tyler Winterton, set for arraignment. Mr. Castleberry.
Thank you, Judge. Your Honor, we have received a copy of the indictment and waive reading. His name is spelled correctly. He understands what he's charged with and the range of punishment for the purposes of arraignment. This morning, we're going to plead not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. And so you're going to get that in writing. And if you get out of jail between now and August the 11th, I need to see you here in court on that day at 9 a.m.
Judge, that's all I have. Excuse me.
Sir, thank you. Mr. Stevens.
Start on page 8.
Yes, sir. Tony Hilton. This is cause number CR 21-0467-173, the state of Texas versus Tony Hilton Jr., set for arraignment. Mr. Stevens.
Yes, sir. If it may please the court, Your Honor, Mr. Hilton would advise the court is saying spelled correctly. He understands the nature and consequences of the charges against him. We will waive reading to the indictment and enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are August the 11th at 9 a.m. for discovery status, and then on September the 8th at 9 a.m. for pretrial. So you're going to receive those in writing. If you get out of jail between now and August the 11th, I need to see you back on that date at 9.
Wait just a second. Judge, are there any other dates beside the 11th of August? I've got 6 cases set in the 422nd in Kaufman at 9 o'clock in the morning. A couple of them, please. I'll be there all morning.
James Ant, 294.
Oh, 422nd.
No, she,
Oh, okay. I thought, no, I meant Kaufman.
for discovery status.
Thank you, sir.
All right, so scratch that. Your discovery status, August 12th at 9 a.m. And then pretrial, September the 8th, 9 a.m.
Your Honor, the underlying offense, we want to set that also on the 12th. The offense for which it's alleged detailed over here.
But it's not on the docket.
It's not on today's docket.
So
No,
what
sir.
is that cause number?
CR 19-328-173.
So we'll also set that one on August 12th. Where is that at? Status?
Yes, sir. It was.
So we'll set it for status. All right, we'll see you back in August, sir. Danny Lopez. It's okay. Oh, is it? Hey, Danny, he's saying that's already set on July 13th for a motion to proceed.
Okay. So the 30 set, July 13th at 1:30. We'll see you in July then, Bill.
Okay.
Come on up, Mr. Lopez. All right, this is CR 21-0503-173, the state of Texas versus Danny Lopez, set for arraignment. Mr. Stevens.
Yes, Your Honor. Your Honor, may it please the court. My client would advise his name spelled correctly. He understands the nature and the consequences of the charges against him. We will waive reading of the indictment, enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are August the 12th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. So if you get out of jail between now and August the 12th, I need to see you back on that date at 9 a.m. Sherdell Shelton. This is cause number CR 21-0514-173, the state of Texas versus Sherdell Shelton. Set for arraignment, Mr. Stevens.
Yes, Your Honor, may it please the court. My client would advise the court his name spelled correctly. He understands the nature and the consequences of the charges. Will waive reading of the indictment, enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are August the 12th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. And so if you get out of jail between now and August the 12th, I need you back here at 9 a.m. Willie Upshaw. Yeah, it's a traffic jam. All right, these are cause numbers CR 21-0026 and CR 21-0469-173. Both are styled the state of Texas versus Willie Upshaw. Set for arraignment on each case, Mr. Stevens.
Yes, Your Honor, may it please the court. My client would advise the court his name spelled correctly. He understands the nature and the consequences of the charges. We will waive reading of the indictment, enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty in each case, and your two next court dates for each of those are August the 12th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. And so if you get out of jail between now and August 12th, I need to see you back at 9 a.m. Thank you, sir. Sir,
I think that's it for me now, Judge.
I think we got you.
Yes, sir.
Yes, sir.
I'll be back this afternoon.
Use the chairs this morning. Yeah, I just realized he's a YouTube star now. All right, Ms. Altier. All right, well, we'll arraign her first. Taylor Smedick. All right. Cause number CR 21 -0498-173, the state of Texas versus Taylor Smetic, set for arraignment. Ms. Altier.
Yes, Your Honor. Ms. Maddox's name is spelled correctly on the indictment. She understands the nature of the charges. We waive the formal reading, and for the purpose of arraignment, she pleads not guilty.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. And now I'll call the case again, CR 21-0498-173, the state of Texas versus Taylor Page Smetic. A plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Smetic,
We are ready. Your Honor.
ma'am, is your name Taylor Page Smetic? All right, you're gonna have to talk a lot louder than that. All right, and are you the same person that was originally indicted by Henderson County Grand Jury for the third-degree felony offense of possession of a controlled substance?
Yes.
All right, you got to step up because we're gonna have to hear you. Step up. I don't have COVID and I'm not gonna bite.
Well,
All right.
Your Honor, her brother did, and that's why I was protecting the court. She suspects.
I've already had it.
Okay.
I'm good.
Okay.
I'm natural immunity. All right, and Ms. Smetic, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes.
And Ms. Smetic, have you ever been treated for any mental health or emotional issues? You understand what's going on in here? And Ms. Altier, do you believe your client is competent?
I do, Your Honor.
Then the court finds she is competent. Ms. Smetic, I know that we just arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? Do you understand the charge?
Yes.
Well, as indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years, nor more than 10 years in the Texas Department of Criminal Justice, and a fine up to $10,000. Do you understand the range? And the plea bargain?
The state's recommending 4 years, probated for 4 years, credit for 71 days served to any future sentence, $1,000 fine, $750 attorney fees, $365 court costs, $180 lab fee, and all special and standard terms and conditions of probation.
Is that your understanding of the plea bargain, Ms. Smetic? And is that your understanding, Ms. Altier?
It is, Your Honor.
Well, Ms. Smetic, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Ms. Altier? And did you sign them? Do you have any questions? Second document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? And did you sign that second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Ms. Altier? Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to enter into this plea bargain? And I'll ask you, ma'am, how do you plead to that third-degree felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are and for no other reason? I'll hear the evidence.
The state has 3 pieces of evidence, Your Honor. The first is an offense and incident report from the day in question. The second is the initial inventory report, and the third is a lab report.
We have received them. No objection, Your Honor.
Admitted.
The state rests and closes.
The defense rests and closes.
All right, then, Ms. Smetic, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of possession of a controlled substance as alleged in the indictment. The court will follow the plea bargain, sentences you to 4 years in the Texas Department of Criminal Justice. However, the court will probate that, place you on community supervision for 4 years. You do have 71 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, lab fee, and abide by all the regular and special terms and conditions of community supervision. Ms. Smetic, have you ever been on probation? Well, there's a lot of things you have to do and a few things you can't do on probation. You understand that? Do you know what can happen to you if you violate any term of this community supervision? What can happen? For how long? Well, actually, you can go up to 4 years. Here's what can happen. If you violate even one term or condition of this probation, a motion would be filed a warrant would be issued for your arrest. You'd be placed in jail with no bond, brought back before the court, and if at a hearing, the court found you violated even one term or condition, the court could revoke your probation and sentence you up to 4 years in prison, you understand? So would you agree with me? It's extremely important that you abide by these terms and conditions. I hope you do, ma'am. Good luck to you. You need to see probation before you leave. And now that you've been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. Thank you, ma'am. Yes.
Nothing further this morning.
Ms. Fallhaber? Had to wade through the crowd to see who was next.
Sir. Got James Huckabee on page 3, please.
James Huckabee. This is cause number CR 21-0493-173, the state of Texas versus James Huckabee, set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. Mr. Huckabee does understand what he's accused of. His name is spelled correctly, waives formal reading of the indictment, enters his plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. And so you're going to receive those in writing. However, based upon the nature of your charge, I'm ordering you to take a drug test today. We'll go with probation, take the test. When you get done, come back here in the courtroom. Don't leave until we talk again. All right.
Janet Lunsford, also on page 3.
Ms. Lunsford. This is cause number CR 21-0476-173, the state of Texas versus Janet Lunsford, set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. Ms. Lunsford's name is spelled correctly. She understands what she's accused of, waives formal reading of the indictment, enters her plea of not guilty.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. You're going to receive those dates in writing, and I'm also ordering you to take a drug test. So you're going to go take the test. When you get done, come back in the courtroom. We'll go over the results together.
Sir, my phone's about to die and I have no way to charge it.
What else you got?
Joe Paroline on page 3 and 4. Yes.
All right, these are cause numbers CR 19-0864 and CR 20-0575-173, both styled the state of Texas versus Joe Paroline, and both set for, well, the newest one set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. Mr. Paroline's name is spelled correctly. He understands what he's accused of. Waives reading of the indictment, enters his plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. And let's move on to the trial docket status. Where are we at there?
Your Honor, I believe we have everything and.
Now, trial docket status either ready or not for trial.
Yeah, we're ready.
Okay, is the state ready?
Yes, sir, Your Honor. I see back in April of last year, it was placed on the jury docket.
All right, where's he at? 31. He can move up pretty quick though, because these cases are pleading. All right, Mr. Paroline, so we'll see you again on August the 11th at 9 a.m. for that older case as well. I'm ordering you to take a drug test today. So go take the test. When you get done, come back into the courtroom. We'll go over the results together. Mr. Mills around here. Let's see if he wants to handle this guy for his phone dies.
Sorry.
Tanisha Miles.
Yes, sir.
Kenesha Miles. CR 21-0388-173, the state of Texas versus Kenesha Miles. All right. The time is now 9:36. She was set for 9 a.m. Is there a Kenesha Miles in the courtroom? I see no one. I hear no answer. Is there a Kenesha Miles appearing via Zoom? I see no one. I hear no answer. She's not in the lobby. The court will entertain a motion.
The state would request bond forfeiture, Your Honor.
Granted, capital issues should be held with no bond. And again, I'm here all day.
Last one I have is Billy Cantrell for plea, please.
Set for arraignment first.
Yes.
Give me just a second here. Mr. Lucian, can you hear me? You're supposed to be here. You're muted, but you were supposed to be here at 9 a.m., not appearing via Zoom. So as soon as we get your attorney in here, I got to handle some other business first. We've got this one and then another attorney, and then I'll handle you. So you just need to stick around. You're on personal bond. It's your responsibility to know when you're supposed to be in court. All right, so CR 21-0505-173, the state of Texas versus Billy Cantrell, set for arraignment first. Ms. Fallhaber.
Yes, Your Honor, I have gone over the indictment with Mr. Cantrell. I believe his name is spelled correctly. He understands the nature of the charges against him. Waives formal reading of the indictment for purposes of arraignment, enters his plea of not guilty. However, we have come to an agreement for a plea.
All right, the court notes his plea of not guilty for purposes of arraignment. Right now, I'll call the case again. CR 21-0505-173. State of Texas versus Billy Cantrell. A plea has been presented to the court. Is the state ready?
Ready, Your Honor.
And on behalf of Mr. Cantrell,
Ready, Your Honor.
sir, is your name Billy Wayne Cantrell?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of evading arrest or detention in count 2 of that indictment?
Yes, sir.
And get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can lower your hand. Mr. Cantrell, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Cantrell, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what would those be? If any, have you been diagnosed with anything?
Yes, sir.
And what would that be?
Bipolar, manic depression.
That's about it. Are you on any medication for that?
Yes, sir.
And is the jail giving that to you as it's prescribed?
Yes, sir.
And so do you understand what's going on in here today?
Yes, sir.
Right. And Ms. Fallhaber, do you believe your client is competent?
I do.
Well, Mr. Cantrell, the law presumes you're competent, and based upon your testimony, your demeanor, and your attorney's statements, I have no reason to find that you're not, so I find you are competent. Mr. Cantrell, I know we just arraigned you on this case. However, would you like the prosecutor to read the indictment out loud? All right, but do you understand the charge?
Yes, sir.
Well, as indicted in count 2 of that indictment, that is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand that
Yes.
range? And the plea,
Your Honor, it's 10 years confinement TDC on count 2 of the indictment. Mr. Cantrell has 100 days credit. He's also responsible for attorney's fees, court costs, and lab restitution. And we're asking the court to consider counts 1 and 3 of the indictment.
your understanding of the plea bargain, Mr. Cantrell,
Yes, sir.
that you were understanding this Fallhaber.
It is with the addition that the state will be abandoning the enhancement paragraphs.
That's correct, Judge.
Please 25 to life if those are true.
Yes, sir.
All right, I need to back up a little bit, Mr. Cantrell. if you were to go to trial, I need to talk about the range of punishment again. If you were to go to trial and you were to be found guilty beyond a reasonable doubt, and at punishment, if a court or a jury were to find both those enhancement paragraphs true, the punishment range would then be not less than 25 nor more than 99 years or life in the Texas Department of Criminal Justice and a fine of $10,000. Do you understand that? All right. All right. Well, Mr. Cantrell, a few minutes ago, you told me you could read and write the English language. I'm going to go over two documents with you. The first, agreed plea recommendation. Did you read and go over both front and back of that document with Ms. Fallhaber?
Yes, sir.
And did you sign them?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Do you have any questions about it?
No.
Do you have any questions about any of the documents that you read and went over?
No, sir.
Well, if you read and went over these with Ms. Fallhaber, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to do this plea bargain?
Yes, sir.
Then I'll ask you, sir, how do you plead to that third-degree felony offense as alleged in count 2 of the indictment? Guilty or not guilty? And are you pleading guilty because you are, for no other reason?
Yes, sir.
I'll hear the evidence.
Judge, I have stage 1, an offense report, and stage 2 is Michael Morton compliance.
No objection.
Admitted.
State rests and closes.
Rest and close, Your Honor.
All right, Mr. Cantrell, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense in count 2. The court grants the state's motion to abandon the enhancement paragraphs, considers counts 1 and counts 3 in sentencing you, follows the plea bargain, sentences you to 10 years in the Texas Department of Criminal Justice. You do have credit for 100 days and orders you to pay your attorney's fees, court costs, and lab fee. And Mr. Cantrell, did you get an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
Sir, now that you have been convicted of this offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Mr. Cantrell. You need to see Mr. Halbert before you leave.
Your Honor, he would just like to hear on the record that this sentence is going to run concurrently with any other sentences he might have.
I don't know about any other sentence he might have. I have no idea. I can't speak for another county or another court.
It says on the paperwork it runs concurrently.
That was-
I don't know of any other charges in any other counties. I'm not aware of a blue warrant or anything like that. I don't know.
I'm on parole for a good one. I got a hold on it right now for a good one.
I don't know. I mean, y'all, that's why we work stuff out in the plea bargain. We don't get up here and try to work it out.
It was part of the deal, and it does say on there.
Yeah, but I need the cause number. Where are the cause numbers? Because they're going to go by that judgment right there.
That's what I agree to, sir.
You got the cause number?
No, it was part of what we worked out. I
Well, I
haven't
think it's a
seen-
matter of law. It's going to run concurrent.
That's what I believe too. And in
And-
the past, when it's a TDC case, I haven't seen the TDC number on the judgment.
Yeah, if it's something that's, I mean, there's very, I don't say very few, but there's a limited amount of ways that something can be stacked. Right? And so there's no other sentence for me to stack it onto. So if you want me to say on the record, it'll run concurrent with any other sentence you're serving as a matter of law. Is that good enough?
It just makes me feel better.
Okay, and if
mean,
something
it will
happens,
also
file a
have-
motion for new trial and I'll consider, I'll look
Right.
at it.
I think you're
I don't
fine.
know how it works, you know.
Well, I do, and it'll, as a matter of law, it runs concurrent.
Thank you, sir.
All right.
Thank you.
You need to see
There you
Mr.
go,
Halbert.
Grant. Your Honor, could we please recall Kanisha Miles? Your coordinator has informed me that she's on Zoom.
She is, but she's not here. And she had the bonds person that certainly would have let her know she had to be here. She's not, it just says connecting. How long has she been connected?
I mean, I'll be here waiting on those.
Yeah,
results
well, as soon as she pops in, we can. Mr. Scott's been standing there a while.
Gregory Ward, Your Honor, on the last page.
Gregory Ward.
arraignment. Your Honor.
All right, this is cause number CR 21-0506-173, the state of Texas versus Gregory Ward, set for arraignment. Mr. Scott.
Your Honor, I got a copy of the indictment. His name is spelled correctly. He understands the nature of the charge against him. Will waive formal reading of the indictment. Enter plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates there in writing. That is August the 11th at 9 a.m. for discovery status. And then again on September the 9th at 9 a.m. I'm sorry, September the 8th at 9 a.m. for pretrial. So you're going to receive those in writing. Can I see the indictment in this case?
Got a copy here. Yes, I got it.
But I'm also going to order him to take a drug test, sir. You'll go take a drug test today. When you get done, come back in the courtroom. We'll go over the results together.
Yes, sir. Yeah, I did get that. Yes, sir.
Who else you got?
Your Honor, I've got Carlton Tarkington for arraignment.
Tarkington, come on up. All right, this is cause number CR 21-0488-173, the state of Texas versus Carlton Tarkington, set for arraignment. Mr. Scott.
Yes, Your Honor. Got the indictment here. His name is spelled correctly. He understands the charges against him. Will waive formal reading of the indictment. Enter plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. So as soon as you receive those reset notice, you can have a seat. And if you get out of jail between August now and August the 11th, I need to see you on that date at 9 a.m. Thank you, sir.
Henry Elo II.
Henry Elo. This is cause number CR 20-0092-173, the state of Texas versus Henry Elo, set for arraignment. Mr. Scott.
Yes, sir. Have the indictment. I've gone over it with Mr. Elo. His name is spelled correctly. He understands what he's charged with. Will waive formal reading of the indictment and enter a plea of not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your 2 next court dates are August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. So if you get out of jail, sir, between now and August the 11th, I need to see you here at 9 a.m. on that day, okay? I'm sorry? You're on a bench one? Well, even if you break out of jail, make sure you're back here on August the 11th at 9 a.m. Thank you, sir.
And I've got a plea too, and I just need to go over those papers with my client.
Okay.
And
You
that's-
still have, you have Christy Jones and Gary
Oh, yeah,
Anderson?
Christy Jones. I haven't, yeah. Christy Jones and who else, John?
Gary Anderson? Which
Yeah,
one's your
Gary
plea?
Anderson is my plea.
You want to do Christy Jones now?
Yes, I think we
All right.
should.
Christy Jones. Christy Jones. Cause number CR 21-0429-173, the state of Texas versus Christy Jones. So Christy Jones in the courtroom. I see no one. I hear no answer. There is not a Christy Jones that I can see appearing via Zoom. She's not in the lobby. The time is now 9:50. She was set for 9 a.m. Court will entertain a motion. Granted, capious issue, she'll be held with no bond. And I'm here all day.
All right, thank you, Judge.
Mr. Giat.
Yes, sir, Judge. Elton Garcia. Herrera Garcia.
Mr. Garcia. Okay.
It's the one he showed up on Zoom. We set it to today.
Gotcha. Find the papers real quick, give the court reporter a quick break.
She
Garcia.
doesn't need a quick break. She's professional.
The thing about the court reporter is, and I didn't just really think about this until I took the bench, is she's the only person that's actually physically working in the courtroom. The rest of us are just using our brains. She's using both. I just said you use both. How efficiently, I don't know.
I've seen the tape. I don't know what it says. So I don't know if she could say it says anything.
I'm not talking fast. I'm moving this one. You ready? You ready? You ready? Let's do it.
Yes, sir. Let's rock it up.
This is cause number CR 20-0528-392, the state of Texas versus Kelvin Jose Barrera Garcia. And that is set for status today. However, a plea has been presented to the court. Is the state ready? I gave you a bunch of names.
We're ready, Your Honor.
And on behalf of Mr. Garcia.
We are ready, Judge.
Sir.
Before it gets started, there should be a 1245 letter from the county attorney's office.
There is.
Okay, I wanted to make sure that that's in the paper.
All right, sir, is your name Kelvin Garcia?
Yes, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury for the second-degree felony offense of manufactured delivery of a controlled substance?
Yes, Your Honor.
Get you to raise your right hand, please, sir.
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
You can lower your hand. Mr. Garcia, can you read and write the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, Your Honor.
And Mr. Garcia, have you ever been treated for any mental health or emotional issues?
No, Your Honor.
Do you understand what's going on in here today?
Yes, Your Honor.
And Mr. Aguiat, do you believe your client is competent?
Yes, sir.
And then the court finds he is. Mr. Garcia, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud?
No, Judge, we'll waive the formal reading.
But do you understand the charge?
Yes, Your Honor.
Well, as indicted, that charge is a second-degree felony, which carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand the range?
Yes, Your Honor.
Plea bargain?
Yes, Your Honor, we are recommending to take into consideration the unindicted misdemeanor and felony from 10/26/19. And then sentenced to 5 years probated for 3 years, $1,200 fine, $415 in court costs, $180 in lab fees, and all standard and special conditions and terms and conditions of probation.
Is that your understanding of the plea bargain, Mr. Garcia?
Yes, Your Honor.
Is that your understanding, Mr. Guiot?
Yes, sir.
Mr. Garcia, a few minutes ago, you told me you could read and write the English language. I'm gonna go over 2 documents with you. The first is the agreed plea recommendation.
Yes, Your Honor.
Did you read and go over both pages of that and sign it with Mr. Guiot?
Yes, Your Honor.
Do you have any questions about it?
No.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Guiot?
Yes, Your Honor.
And did you sign the second page?
Yes.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with Mr. Guiot?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury.
Yes, sir.
Do you want a jury trial?
No.
Do you want to enter into this plea bargain?
Yes.
Then I'll ask you, sir, how do you plead to that second-degree felony offense of manufactured delivery as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I hear the evidence.
State has 3 pieces of evidence to present, Your Honor. The first is an incident report, the second is an inventory report, and the third is a lab report.
Your Honor, we have no objection to 1, 2, or 3.
All 3 are admitted.
And the state rests and closes.
I would like to ask my client a couple questions. when we
Okay,
complete the
he's
judge.
under oath.
Mr. Garcia, my name is Paul Guiot. You hired me to represent you, is that correct?
Yes, Your Honor.
You satisfy my representation? Yes. Have I answered all of your questions? Yes. Have I done everything you've asked me to do? Yes. That's all I have.
Nothing, Your Honor.
All right, close.
Close.
All right, Mr. Garcia, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that second-degree felony offense as alleged in the indictment. In sentencing you, the court is considering the unindicted possession of marijuana and the filed UCW. The court sentences you to 5 years in the Texas Department of Criminal Justice. However, the court will probate that, places you on 3 years community supervision. You do have 2 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, court costs, lab fee, and abide by all the regular and special terms and conditions of community supervision. Mr. Garcia, have you ever been on probation before?
Yes, Your Honor.
Did you successfully complete it?
Yes, Your Honor.
So you know what it takes.
Yes, Your Honor.
You know what can happen to you if you don't successfully complete this probation.
Yes, Your Honor.
What can happen?
5 years.
That's right. You can do 5 years. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest. You'd be placed in jail without bail, brought before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you to 5 years in prison. You
Yes,
understand?
Your Honor.
So would you agree with me? It's extremely important you abide by these terms.
Yes, Your Honor.
I hope you do, sir. And before you go, now that you've been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. You need to see probation before you leave. Good luck, sir.
Have a seat, Your Honor.
Sir, see you. Have a good one. You too. Mr. Mills?
Did I think Mr. Lucian Zoom in?
He did, and then he broke in the middle of my hearing and told me his phone was about to die. So,
Oh,
and then he fell off.
oh, they always on the gone.
I don't know who this 214 number is. Mr. Lucian on Zoom? He's on personal bonds, the way I look at it. When you sign up for that, you're
Maybe he'll
on-
charge his phone up and get back in touch with
I'm
somebody.
here all day.
I won't be. If he gets whatever.
Yeah, I'll take it. I mean,
go from there. We have a plea and we. think we really Needs to be smart. in these places.
while you're doing that, I'm going to just go over the docket real quick, make sure I've got everybody here. Efren Garcia. That's set for a plea today at 10. Okay. Okay. Stephen Holsey. All right, your attorney, I think, had court in Palestine this morning, did he not?
Yeah, he said he'd be here as soon as he could.
Okay, and if he's not, by lunch, we'll just bring you over after lunch. Mr. Abundez, I've seen him. We're doing a plea on him. Gary Anderson. Did we do? Okay, that's right. He was going to be a plea, I think. Did I do Billy Driver?
No, Your Honor.
Okay, that's a plea. Felicia Bieg. B-I-E-G. Felicia B-I-E-G.
She's here filling out paperwork.
Gotcha. Rodney Brackens. Okay. Mitchell Roberts. Okay. And Nicole Turner. Nicole, okay. Do you have an attorney? Are you gonna hire one or are you filling out paperwork? Okay, we'll wait and see. I'm gonna take about a 10-minute recess and then we'll come back and finish up.
Thank you.
Well, I went over there before you, instead of getting on, good.
Now, Mr. Abundez, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here today?
Yes.
All right, and Mr. Mills, do you believe your client is competent?
Yes, Judge, he is.
All right, and Mr. Abundez, I know that we've already arraigned you on this case. But would you like the prosecutor to read the indictment out loud in the courtroom?
No, Your Honor, we'll wait. He understands what he's charged with.
Well, as indicted, that charge is a first-degree felony, which carries a punishment range of not less than, it's a 25 at first, right?
That's correct.
Not less than 25 years nor more than 99 years or life in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand that range of punishment?
Yes.
However, it's my understanding that the state is willing to allow you to plead to the lesser included offense of aggravated sexual assault of a child. That is also a first-degree felony, but it carries a punishment range of not less than 5 years or more than 99 years or life and a fine up to $10,000. Do you understand that range of punishment
Yes.
in the plea bargain?
Your Honor, on that first degree felony of aggravated sexual assault of a child, the state recommends 30 years TDC with 767 days credit as of today's date. To include $1,200 in attorney's fees and $365 in court costs. Also, that the defendant abide by the terms of the agreed lifetime protection.
Is that your understanding of the plea bargain, Mr. Abundez?
Yes.
Is that your understanding, Mr. Mills?
Yes, Judge, it is.
Well, Mr. Abundez, a few minutes ago, you told me that you could not read and write the English language, but that you have had the assistance of an interpreter in going over this paperwork and in consulting with your attorney. Is that correct?
Yes.
So I'm going to go over two documents. The first is the agreed plea recommendation. Did you go over both the front and back of that document with Mr. Mills with the help of the interpreter?
Yes.
And did you sign the front and the back?
Yes.
Do you have any questions about it?
No.
And again, with the help of the interpreter, did you go over this court's admonishments and warnings prior to entering a guilty or no contest plea? And did you sign that second page?
Yes.
Do you have any questions about it?
No.
Do you have any questions about any of the documents you read and went over with Mr. Mills with the help of the interpreter?
No.
Well, if you read and went over these with Mr. Mills, I know that not only did he explain to you that he may not know what may happen with immigration, but he also explained to you that even though you are not a U.S. citizen, you are in the United States and are afforded certain protections under our Constitution. Do you understand that?
Yes.
And you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to enter into this plea bargain?
Yes.
Do you want to wait and consult with an immigration attorney, or do you want to do this today?
Today.
Then I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, the aggravated sexual assault of a child? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason? I hear the evidence.
State offers Exhibit 1, a copy of the offense report, Exhibit 2, the initial inventory report, and Exhibits 3 and 4, the lab report.
Admitted.
State rest and closure.
Rest in close.
Is the complaining witness and or the family on board with the plea bargain?
Yes, Your Honor.
Okay. And you have a statement you're going to read after?
Yes, Your Honor.
Okay. And any evidence?
No, rest close.
All right, then, Mr. Abundez, those are admitted. Mr. Abundez, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense of aggravated sexual assault of a child. The court will follow the plea bargain, sentences you to 30 years in the Texas Department of Criminal Justice with credit for 767 days as of today, and orders you to pay your attorney's fees, court costs, and lab fee, and notes that you agree to this lifetime protective order. And Mr. Abundez, a couple of other things before you go. Did you get an opportunity to review the judgment through the interpreter in your case? Is your name, the charge, and the time credit correct? All right, sir. Now that you've been convicted of this felony offense, you are now under Texas law and eligible to possess a firearm or ammunition. And you're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. All right, and I believe that Ms. Pace has a statement that she is going to read to the court on behalf of the family. So you ready?
Yes, Your Honor.
Yes.
This statement is from Genesis Abundez, 12-year-old victim in this case. So I was told to write how I feel about this situation that had been going on for about 2 years, and so I'm going to do so. First, general well-being. First things first, I feel like this is my fault for not telling anyone when I had the chance, or like when my mom had asked me so many times before I actually told her. I feel like it was my responsibility to tell an adult or someone I trusted, but I didn't because I was very scared and very young to know that what he, Dad, said to me, that it was all right for what he was doing. He had manipulated me into thinking it was all right for what he was doing. But now, obviously, I know it was not. For what all has been happening these past 2 years, I have dealt with trust issues, depression, anxiety, and other things. These 2 years have been the hardest. I feel like I didn't matter to my father in any sort of way. I thought I was going to be very protected by my father from other bad people. But in this case, he was the bad person. I feel like I was a doll to him and I was being controlled and manipulated by his words and actions. I've always felt like I had no purpose in life. Sometimes, most of the times, I feel like I am just a mistake and was never meant to happen. And as if slowly I start to accept that this has not been my fault, I have some part of me that still is. I can't even go to sleep without thinking he's going to come and do something very harmful to me or my family. I am still yet very scared, and I think that most men will try to hurt me, but that's not the case. Some men are good and they will do no harm to me. This man, father, has done so much harm to not only me, but my family, which I will never forget him. He has made me have nightmares and very bad memories. I feel very angry and sad. He was supposed to protect me, but all he did was cause me harm. I have so much anger in me that I do not show, which makes me sometimes blow up on my mother or one of my family members. I do not do this because it's their fault, but because I've kept this anger in me for so long. Sometimes I feel like no one cares about me, but I know for what all my family has done for me is more than enough to feel loved, but I feel lonely and unloved. In school, I feel as though I have to be happy even when I'm not. My grades have been going lower and lower. I try to do the best I can for my mother because I know all she wants me to do. I go forward in life. I can't even go to school without thinking someone will find out about my life, about my father. I feel very embarrassed for even my brothers to know what he had done to me. I can't even go socialize because I'm scared that someone I talk to will find out. I have developed a very bad thought about myself, which is not loving myself. Therapy has helped me a lot, but sometimes I feel like it's not doing that good because I'm in my same place where I used to be, miserable. Sometimes I stay in my room for most of the time of the day because all I can do is just sit or lay down. I just don't have no motivation to do anything. I can't even take good care of myself without feeling like there's something pushing me down. I can't even take a proper shower without feeling disgusted. I can't do dishes without having any memories. I can't do most things without feeling sad or having some type of memory. I can't even eat something without remembering if he ate it or not. Same thing with music. When I see or hear something about my father used to do, I burst up into tears. I just feel like I didn't matter to him. I feel like I was nothing to him, just a piece of trash to him. I have to drink medicine because of him, but I'm scared that one day I will not be able to take this pain anymore and just die. I'm scared of my own thoughts, and sometimes I see some people with their fathers and they're happy. I feel so sad. I'm tired. I just want to be happy. I can't count how many times I've just wanted to give up, but the only reason I'm still here is because I want to show my mom that I can be strong just like her. I want to show my brothers that I'm not weak, but sometimes all I am is weak. And it's hard. It's really hard. I just see no other reason why I should still be alive. One of my bad ways to cope is to self-harm, and I know it's not good, but I just do it. Sometimes I feel like I deserve for everything that's happening to me. And the worst thing of all that has gotten so much anger in me is the way he has treated my mom. My mom has been through so much with that man. I will never forgive that man. I'm so happy that he's going to prison and I hope he rots there. I'm not saying that he can go die because I know God will not like that and I wish no more harm for him, but to pay for what he has done to my family, God will make him pay for the rest. I'm just 12, okay? You've messed up my whole life. Now, not only for what you did to me, but what you have caused to this family. We've not done anything to you to make us feel this way. You are not my father anymore. I care no more for you. You have a daughter no more.
Thank you, ma'am. Mr. Abundos, you need to see Mr. Halbert before you have a seat. Sir. Paul
Got Nicole Lamar Turner.
Turner, come on up. I see the indictment. For 495. All right, these are cause numbers CR 21-0495 and 0496-173, both styled the state of Texas versus Nicole Turner, and both set for arraignment. Ms. Fallhaber.
Thank you, Your Honor. I have confirmed that his name is spelled correctly. He does know what he's accused of. Waive formal reading of the indictment, enter pleas of not guilty for purposes of arraignment.
All right, sir, the court notes your pleas of not guilty on each case for purposes of arraignment. And you're going to receive 2 new court dates there in writing. That's August the 11th at 9 a.m. for discovery status. And then again on September the 8th at 9 a.m. for pretrial. And so you'll receive those in writing. I'm going to order you to take a drug test today. You're going to go take the test. When you get done, come back in the courtroom. We'll go over the results together. So don't leave until we talk about those drug test results.
Your Honor, the state also requests that the court put the sex offender bond conditions on its concurrence.
Granted. And so if you'll give them, get them prepared, I'll sign them. Oh, there you go. Already.
Thank you.
All right, go take that test, and when you get done, come back in the courtroom. We'll go over the results. Mr. Scott.
Oh, I still have some.
Oh, sorry.
That's okay. I have results for Jana Lunsford. It was clear.
Ms. Lunsford, come on up. Does she already have conditions? Probably not. Back on the record in cause number CR 21-0476-173. And Ms. Lunsford, based upon the nature of her charge, was ordered to take a drug test after she was arraigned. She has tested negative. However, Ms. Lunsford, I am still going to place you on conditions of bond because of your charge. There'll be no alcohol, no drugs that are illegal, no drugs not prescribed, and no marijuana or THC in any form or format, no matter where you're at. You understand? Shouldn't be a problem. You tested
No.
negative.
I've been cleaning.
Good for you. I like to hear that. So you have those bond conditions, and we'll see you in August.
Okay.
As soon as you receive them, you're free to go.
Results for James Huckabee.
James Huckabee. This is back on the record in cause number CR 21-0493-173. State of Texas versus James Huckabee. And again, after arraignment, Mr. Huckabee was ordered to take a drug test based upon the nature of his charge. Mr. Huckabee has tested positive for methamphetamine and amphetamine, and apparently admitted to smoking meth on June the 8th, just a few days before he's arraigned. A couple days. And so Mr. Huckabee, everybody gets their one free shot in this court. I'm placing you on conditions of bond, no alcohol, no drugs not prescribed, no illegal drugs, no THC or marijuana, no matter where you are or in what form it may be in. And so I'm signing these. If you have any questions, ask your attorney. I am going to test you again in March. If you test positive, I can't promise which door you will leave out of the courtroom. If you need help, get it. I would rather have you in help than in jail. But if I have to put you in jail for your own safety and that of the community, I will.
You got it. Probation with the green copy.
It says it on the bottom. Yeah.
Yellow, this is copy for you, yellow.
It says it on the bottom who gets it.
Oh, okay. Goldenrod is probation. I've been getting the wrong one all this time.
Got anything else?
Yes, Joe Paroline.
Mr. Paroline, come on up. All right, this is cause number CR 19-0864 and CR 20-0575-173, both styled the state of Texas versus Joe Paroline Jr. And was he arraigned on both of those, or one of those is an older case?
This one is the one that's on the third that came over.
You set bond conditions.
Okay, but this is the first time I drug tested him, right? Okay. All right, well, Mr. Paroline, or Mr. Paroline? Paroline, sorry. I got you. It looks like you have tested positive for methamphetamine, amphetamine, THC, and cocaine. If you were playing baseball, you'd have a pretty good average there. But this ain't baseball, it's life. And so you apparently admitted to smoking yesterday weed, cocaine, and meth, which tells me you're probably still under the influence while you're standing here in a state district court answering for a felony charge. Not a really bright thing to do. But I give everybody their one free shot. So you already have conditions of bond. I'm going to tell you what they are in case you didn't get a copy. No alcohol, no drugs not prescribed, no illegal drugs, and no THC or marijuana, no matter where you're at or in what form it's in. You need help. And so I would highly encourage you to get it. And you're going to drug test again in August. And if you test positive, I can't promise which door you'll be out of. And I won't hesitate to put you in jail if I can do so to help you, but I'd rather you get help on your own. There's lots of it out there. Good luck to you, sir. I'll see you in August.
The last one's Kanisha Miles, who I believe is still on Zoom.
Okay. Did she get prior approval to appear via Zoom?
No, I spoke with her bondsman. Apparently, she had gotten a new phone number and did not get in touch until this morning.
Yep.
So her bail bondsman just gave her the login, and her bondsman also told me that she's sick.
I just find there's a coincidence that people that are going to get drug tested always are the ones that end up being sick. And it's probably because they're on drugs and maybe their immune system is suppressed. Or it could be that they know that they're going to be drug tested.
Understood, Your Honor.
I'm just saying that out loud. I speak the truth now. Political correctness has gone out the window. I'm not woke at all. Just whatever it is, I'm just going to say it.
You know, last year took its toll on all of us.
Yes.
didn't it?
All right, Miss Miles, can you hear me? Miss Miles cannot hear me. Miss Miles, and I am not muted. Let me just do this. Well, there's nothing I can do because she's not muted.
You know, I'm gonna be here for that last drug test result. Why don't I try calling her on? her
Sure,
number?
and tell her I'm trying to call her.
Yes, sir.
Okay.
Thank you.
All right. Mr. Scott,
Gregory Ward, Your Honor, he's sitting for a drug test.
Mr. Ward, come on up.
Plain, other than he had a prescription.
Okay,
It's evading arrest. This
understood.
is charge.
Right. Well, sometimes appearance and demeanor, and I'm not right all the time. All right, this is cause number CR 21-0506-173, the state of Texas versus Gregory Ward. Mr. Ward was sent to take a drug test. He has tested positive, but has a prescription. And so I guess that would cover that. Okay. All right. Well, then, Mr. Ward, we'll see you in August. You're free to go, sir.
Okay, thank you.
All right. Hey, Your Honor, I told Mr. Mills to get cut in front of me and we both have pleas. That's okay.
A quick arraignment and a plea?
No, just.
Okay.
I was saying Ann and I both have
Oh, I
pleas.
thought you said, and we both have pleas.
I just got appointed this morning on our Miss Beeg.
Come on up, ma'am. How do I say your name? Beeg? Okay. How come I can't find her?
Page 10.
All right. This is cause number CR 21-0458-173, the state of Texas versus Felicia Beeg, set for arraignment. Mr. Mills.
Your Honor, I was just appointed a few minutes ago to represent Miss Beeg, but her name is spelled correctly in both indictments. She understands what she's charged with. We'll waive the reading of both indictments and plead not guilty to both the charges.
All right, ma'am, the court notes your plea of not guilty for purposes of arraignment. And you're going to receive 2 new court dates there in writing. That is August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. And so you'll receive those in writing. However, before you go, I'm going to order you to take a drug test. You're going to go take the test. When you get done, come back in the courtroom. We'll go over the results together. And I know you're going to go.
Oh, okay, we'll get hold of it.
Mr. Scott.
Your Honor, I've got Rodney Brackens Jr. for arraignment.
Mr. Brackens. Okay, I took a break.
My VA benefits.
Are you?
Yeah, they sent me to the dermatologist here in town the other day. It's great. Some thing. They thought it might be cancer off me, but it wasn't.
I gotta tell you my dermatology story, but I'm not gonna do it on Zoom.
I remember you were all scarred up or something on your face or something. We're ready, Your Honor.
All right, cause number CR 21-0454-173, the state of Texas versus Rodney Bracken, set for arraignment. Mr. Scott.
Yes, sir. Got a copy of the indictment here. Mr. Bracken's name is spelled correctly on the indictment. He understands the nature of the charges against him. Will waive formal reading of the indictment, enter pleas of not guilty.
All right, sir, the court notes your pleas of not guilty for purposes of arraignment. Your two next court dates are August the 11th at 9 a.m. for discovery status.
Yes, sir.
And then again on September the 8th at 9 a.m. for pre-trial. And so we'll get those in writing. I am going to order you to take a drug test today. You're going to go take the test. When you get done, come back in the courtroom. We'll go over the results together. All right. Yeah, I can get online. I'll figure out her name. Let you consult with her. Reference, yes.
And I've got a plea, Your Honor, on Gary Anderson.
Mr. Anderson. I'm kind of surprised. Just wasn't ready for that.
I would be too. I'm gonna like take my shirt off at the beach, so that would make me very uncomfortable.
All right, this is cause number CR 21-0517-173, the state of Texas versus Gary Wayne Anderson. And this is set for, what was it set originally for?
Arraignment, Your Honor.
And we haven't
For our
arraigned him
first
yet?
hearing. We have not, Your
All
Honor.
right, so set for arraignment, Mr. Scott.
Got a copy of the indictment. He does understand what he's charged with. His name is spelled correctly. We'll waive reading of the indictment and plea of not guilty for purposes of hearing.
All right, sir, the court notes your plea of not guilty for the purposes of arraignment. And let's see, I'll call the case again. Cause number CR 21-0517-173. The state of Texas versus Gary Wayne Anderson. A plea has been presented to the court. Is the state ready?
We're ready, Your Honor.
And on behalf of Mr. Anderson.
We're ready, Your Honor.
All right, sir, is your name Gary Wayne Anderson?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of unauthorized use of a vehicle?
Yes, sir.
Get you to raise your right hand best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Anderson, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Anderson, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes, sir.
And Mr. Scott, you believe your client is competent?
I do, Your Honor.
Court finds he is. Mr. Anderson, we just arraigned you on this case. However, would you like the prosecutor to read the indictment out loud?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted originally, that charge, is a state jail felony, which carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine up to $10,000. Do you understand that range?
Yes, sir.
However, it's my understanding you have this agreement worked out with the state where in exchange for your guilty plea, you would be convicted as a state jail felon. However, it would be punished as a misdemeanor. A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine up to $4,000. Do you understand that range of punishment
Yes, sir.
in the plea bargain?
Your Honor, it's 141 days confinement in Henderson County Jail, credit for 141 days served. Mr. Anderson is responsible for attorney's fees and court costs.
Is that your understanding of the plea bargain, Mr. Anderson?
Yes, sir.
Is that your understanding, Mr. Scott?
Yes, Your Honor.
Mr. Anderson, a few minutes ago, you told me you could read and write the English language. I'm showing you two documents. The first is the agreed plea recommendation. Did you read and go over the front and the back with Mr. Scott and sign them both?
Yes, sir.
Any questions?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second?
Yes, sir.
Any questions?
No, sir.
Any questions about any of the documents you read and went over with Mr. Scott?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to waive your right to a jury trial and enter into this plea bargain with the state?
Yes, sir.
And I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment, punished under 1244A of our penal code? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I hear the evidence.
Judge, I have states 1 and offense report, and states 2 is Michael Morton compliance.
No objection, Your Honor.
Admitted.
Rest and close, Judge.
Defendant rest and close, Your Honor.
All right, then, Mr. Anderson, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense of unauthorized use of a vehicle. The court will follow the plea bargain, sentences you to a Class A misdemeanor to 141 days in the Henderson County Jail with credit for 141 days and orders you to pay your attorney's fees and court costs. And before you go, Mr. Anderson, did you get an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, and finally, sir, now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult an attorney. Need to see Mr. Halbert before you go, and if there's nothing else holding you, I've signed an order for your release. Good luck.
Yes, sir. Judge, he does have a hold out of another county.
Okay, well, you go there and take care of your business there.
Yes, sir.
Mr. Halbert, yes, sir.
Everybody see something?
Yes, sir.
That's probably not fine. Make sure he gets it. Your Honor, I'm just waiting around. Mr. Bracken's drug test. I'll be here.
Ms. Thompson?
Thanks, Jim. This is Robert for Elaine.
Mr. Driver, come on up. Morning. Almost afternoon, but we're getting there. So he's pleading on, well, this is just one, yeah. Let me get the paperwork signed up real quick. Well, let's go ahead and arraign him. This is cause number CR 21-0344-173, the state of Texas versus Billy Driver, set for arraignment. Ms. Thompson.
Your Honor, we have received a copy of the indictment. His name is spelled correctly. He does understand what he's charged with. For purposes of arraignment, he pleaded not guilty, waives reading of any formal indictment.
All right, Mr. Driver, then the court notes your plea of not guilty for purposes of arraignment. And now I'll call the case again. Cause number CR 21-0344-173, state of Texas versus Billy Driver. And a plea has been presented to the court. Is the state ready?
Yes, sir.
And on behalf of Mr. Driver,
We're ready, Your Honor.
and I think you missed a signature there. I miss 8 or 9 a day, trust me. All right, sir, is your name Billy Bryce Driver?
Yes.
And are you the same person that was originally indicted by a Henderson County grand jury for this state jail felony offense of possession of a controlled substance? And get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Mr. Driver, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Driver, have you ever been treated for any mental health or emotional issues?
Your Honor.
You understand what's going on in here?
Yes, sir.
And Ms. Thompson, do you believe your client is competent?
He is competent.
The court finds that he is. Mr. Driver, I know that we just arraigned you on this case. If that's for me, tell him I'm on the bench. I'll call him back. I know that we just arraigned you on the case. However, would you like the prosecutor to read the indictment out loud?
No, Your Honor.
But do you understand the charge?
Yes, Your Honor.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine up to $10,000. Do you understand the range?
Yes, Your Honor.
And the plea bargain?
The state is recommending that to take into consideration the unindicted failed to appear from 5/13/21 and to sentence the defendant to 18 months, probated for 4 years, credit for 42 days served on any future sentence, $1,500 fine, $500 attorney's fees, $365 court costs, and $180 lab fee, as well as any special and standard terms and conditions of probation.
Is that your understanding of the plea bargain, Mr. Driver?
Yes, Your Honor.
And is that your understanding, Ms. Thompson?
Yes, it is, Your Honor.
Mr. Driver, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. First is the agreed plea recommendation. Did you read and go over that with Ms. Thompson,
Yes, Your Honor.
both the front and the back?
Yes, Your Honor.
And did you sign the front and the back?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, Your Honor.
Did you sign the second
Yes, Your Honor.
page? Do you have any questions about it?
No, Your Honor.
Do you have any questions about any of the documents you read and went over with Ms. Thompson? Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, Your Honor.
You want to do this plea bargain?
Yes, Your Honor.
And I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I'll hear the evidence.
The state has 3 pieces of evidence, Your Honor. First, we have the investigation report from the day in question. Second, we have an initial inventory report. And finally, we have a lab report.
What day in question?
The day of the incident.
It's a joke. I didn't know we had a day in question. I just thought that was,
No objection.
I admitted.
That's what the state rests and closes.
Anything else?
No, rest close.
All right, then, Mr. Driver, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court will follow the plea bargain, takes into consideration the unindicted failure to appear, sentences you to 18 months in a state jail felony facility. However, the court will probate that, place you on community supervision for 4 years. You do have 42 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and lab fee, and abide by all the regular and special terms and conditions of community supervision. Mr. Driver, have you been on probation before?
No, Your Honor.
All right, well, there are a lot of things you have to do and a few things you can't do while on probation. And do you know what can happen to you if you violate even one term or condition?
Yes, Your Honor.
What can happen?
Go to jail, go to prison.
Go to state jail. And do you know how state jail time is served? Generally day for day. So if you get 18 months, generally you do 18 months. Here's what can happen. If you violate even one term or condition of that community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be held in jail with no bond, brought back before the court, and if at a hearing, the court found it true that you violated even one term or condition, the court could revoke your probation and sentence you to 18 months in state jail. So would you agree with me? It's extremely important you abide by it.
Absolutely.
I hope you do, sir. Good luck to you. As soon as you get out of jail, you need to see or contact probation. You need to see Mr. Halbert.
Yeah, all right, one more, just give them to me an arraignment. I need to go speak to you. for just a
Sure. Myself at the day in question. I know we had a question. Ms. Fallhaber.
Thank you, Your Honor. So Ms. Miles, I had her log out and back in because she said she could hear you and that she was responding, but it informed her we couldn't hear her.
But she's not here. I mean, why isn't she here?
I texted with her since I've been in the courtroom waiting on the other case. Do you want me to call and ask that question?
I mean, have I already granted a bond forfeiture on her? I mean, she said, is this the one that you said she was sick?
She told her bondsman that she's sick, and I'll be here this afternoon, Your Honor, if you would be inclined to hold it open and see if I can get her here in
Sure.
person.
I always, I've always, hear what they have to say, but I mean, she has a bondsman and it just seems like had a lot of people that just don't show up like her.
Yes, Your Honor.
And I don't know what the state's doing to make sure that these bonding companies do what they're supposed to do. I don't know. Do y'all enforce these things or? Okay. I mean, because there's some bondsmen and bond companies that go get their people and bring them here, and there's some that just, no, they're not here. So, yeah, I'll be here this afternoon.
Okay, I will tell her she needs to get here in person.
Yes, ma'am. Thank
Okay,
you.
thank you. And then I think we might have results.
Hello,
Oh, there she is, Miss Miles.
I've been on, I didn't know how to.
Say that again, Miss Miles.
I've been on the into every, just don't know how to learn how to what's here.
She must have a bad connection.
Miss Miles, you need to be in court. You were told to be in court, not on Zoom.
Sir,
You were told to be in court. Why are you appearing via Zoom?
I said I have been on the street. I have been, and I told her like symptoms. And so she had put me,
I'm not quite sure that's a bad connection. Might be a bad connection somewhere else.
sir.
Miss Miles, you're supposed to be in court. I am going to reconvene court at 1:30. I need to see you here. Did you hear me?
Yes, I
Okay,
can hear you.
I'll see you at 1:30 here in the courtroom.
Okay, so if I'm
Thank
not
you,
at
ma'am.
30, do I call?
And then who else do you have?
Nicole Turner.
Nicole Turner.
Results.
I don't think I had the results yet. do
Oh, okay. I apologize. I just saw him
It's
back
all
in the
right.
courtroom.
Go down and see. I don't have the results yet. We'll have them in a few minutes.
Sorry.
It's okay. Mr. Weiner.
Page 4, Efren Garcia.
Hello?
See you at 1:30, Miss Miles, in the courtroom.
Goodbye.
Okay, all right, and I'll swear the interpreter first. You solemnly swear or affirm that you will translate from English to Spanish and Spanish to English to the best of your ability.
I do.
All right, thank you. All righty, this is cause number CR 19-0908-173, the state of Texas versus Efren Leon Garcia. And that is set for a plea today. Is the state ready?
We are, Your Honor.
And on behalf of Mr. Garcia,
We're ready, Judge.
sir, is your name Efren Leon Garcia?
Yes.
And are you the same person? Are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of driving while intoxicated?
Yes.
All right, if I get you to raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
You can lower your hand. Mr. Garcia, can you read and write the English language?
no,
Okay. But have you had the help of an interpreter in discussing your case and going over this paperwork with both Mr. Head and Mr. Weiner?
yes,
And did you understand through the interpreter what these documents meant and what they said?
yes,
And Mr. Garcia, are you a U.S. citizen?
no,
And did Mr. Weiner and Mr. Head explain to you that although they are not immigration attorneys, that if you enter into this plea bargain, it can have certain negative immigration consequences?
yes,
And immigration law is a very special form of law. And the only person that could give you the best advice about that would be someone who specializes in immigration. Do you understand that?
yes,
All righty. And Mr. Garcia, have you ever been treated for any mental health or emotional issues?
no,
And do you understand what's going on in here today?
yes,
And Mr. Garcia, I'm sorry, Mr. Weiner, do you believe your client is competent?
I do, Your Honor.
And the court finds he is competent. Mr. Garcia, I know that some time ago we arraigned you on this case. However, would you like the prosecutor to read the indictment out loud?
no,
But do you understand the charge?
yes,
Well, as indicted, this charge is a third-degree felony, which carries a punishment range of not less than 2 years or not more than 10 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand that range of punishment
yes,
and the plea bargain?
Your Honor, it's 7 years confinement in TDC, probated for 5 years with 2 days credit towards a potential future sentence. Mr. Garcia is responsible for fine, attorney's fees, court costs, lab restitution, and all the regular terms and conditions of probation, including the installation of ignition airlock device for 2.5 years.
Is that your understanding of the plea bargain, Mr. Garcia?
yes,
And is that your understanding, Mr. Weiner?
Yes, and he already has a ignition interlock device already installed on his vehicle, Judge.
All right, then, Mr. Garcia, a few minutes ago, you told me that you could not read and write the English language, but that you had assistance through the interpreter. Is that correct?
yes,
Well, I'm going to show you 2 documents. The first is the agreed plea recommendation. Did you, with the assistance of the interpreter, go over both the front and back of that document? And did you sign the front and the back?
yes,
Do you have any questions about it?
no,
Same thing with the next document. With the assistance of the interpreter, did you go over that document, both pages with Mr. Weiner?
yes,
And did you sign that second page?
yes,
Do you have any questions about it?
no,
Do you have any questions about any of the documents that you went over with Mr. Weiner with the interpreter?
No.
Well, if you read and went over these with him, I know that he explained to you that even though you may not be a U.S. citizen, you are in the United States and you are afforded certain constitutional protections. Do you understand that?
Yes.
And you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
Do you want to stop and consult with an immigration attorney to see what effect, if any, this plea may have, or do you want to continue on?
I want to plead guilty.
Okay, then I'll ask you, sir, how do you plead to that third-degree felony offense of driving while intoxicated as alleged in the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Judge, I have states 1 in offense report, states 2 is Michael Morton compliance, and stage 3 is a lab report.
Judge, we've previously received, reviewed, and have no objection to any of the state's offers.
Admitted.
State rests and closes.
We rest and close as well, Judge.
All right, then, Mr. Garcia, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that third-degree felony offense of driving while intoxicated. The court will follow the plea bargain, sentences you to 7 years in the Texas Department of Criminal Justice. However, the court will probate that, places you on community supervision for 5 years. You do have 2 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and abide by all the regular and special terms and conditions.
Your Honor, I just thought of something. Can I speak with Mr. Weiner real quick?
Supervision. Had to finish it. I know what y'all are talking about. What do you want to do?
I believe that we can suspend that.
The 10 days?
Yeah.
I knew that's what y'all were talking about as soon as you
Yeah.
stepped away.
I mean, at least in practice, I've done it many times. So if the state doesn't have any objections, since we've got the plea work done already.
Yeah.
That's okay with the court.
I thought as soon as you went around, I
Yeah.
thought the 10 days. And the court also is ordering as a condition of probation that Mr. Garcia is to spend 10 days in Henderson County Jail. He has credit for 2, and the court will suspend 8 of those days.
Thank you,
Is that
Judge.
okay with everyone?
Sure. So explain that he's not going to jail. Okay, it's okay. Okay. Yes, thank you, Judge. Thanks to the state.
And I wrote on there 10 days in Henderson County Jail with credit for 2 days suspended.
Great. Thank you, Judge. I didn't think. Thanks, Judge.
Already found him guilty.
Yes.
Already sentenced him. I added that. All right, Mr. Garcia, have you ever been on probation before? I bet you have with these prior DWIs.
Yes.
And did you successfully complete them?
Yes.
So you know what it takes. Do you know what can happen if you violate this probation?
Yes.
Right. If you violate this probation, even one term or condition, a motion could be filed, a warrant would be issued for your arrest, you'd be placed in jail without bond, brought back before the court, and if at a hearing, the court found it were true that you violated even one of these terms or conditions, the court could revoke your probation and sentence you up to 7 years in prison. Do you understand? Good luck to you, sir. Need to see probation before you leave, and Mr. Halbert. And now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. Good luck, sir.
Thank you, Your Honor.
Sure.
That's all our business. Till this afternoon, may I have
Yes,
excused?
sir.
Thank you, Judge.
Ready on the results for Mr. Turner, please?
Mr. Turner, come on up. I don't have those either. Ah. All right, this is back on the record and cause numbers CR 21 -0496 -173 and 495 -173. Both styled state of Texas versus Nick Cole Turner. And Mr. Turner was ordered to take a drug test today after arraignment. And he has tested positive for THC and cocaine and admitted to smoking marijuana laced with cocaine yesterday, which means you're probably still under the influence. Maybe, maybe not. But Mr. Turner, I'm going to place conditions of bond on you. No alcohol, no drugs not prescribed, no illegal drugs, and no THC or marijuana, no matter where you're at or any form or fashion that it may come in. And so you're going to get those conditions of bond. When I see you in August, I'm going to drug test you again. If you test positive, I can't promise which of these doors you'll go out of. You understand that? And if you need help, ask. I'd rather have you in help than in jail. But if I need to put you in jail to protect you and the community, I will. And so if you need help, ask somebody. And once you receive these conditions, you're free to go, sir. I'll see you in August.
Maybe excuse me until this afternoon.
Yes, ma'am. Thank you. Ms. Thompson.
Your Honor, I don't know what things is wrong with this, Kenneth Wayne, St. Clair Junior. arraignment.
He's telling me he doesn't need a drug test. Mr. St. Clair. All right, this is cause number CR 21-0494-173, the state of Texas versus Kenneth St. Clair Jr., set for arraignment. Ms. Thompson.
Your Honor, we have received a copy of the indictment. His name is spelled correctly. He does understand what he's charged with. For purpose of today's hearing, we enter a plea of not guilty and waive any reading of the formal indictment.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're going to receive 2 new court dates in writing. That is August the 11th at 9 a.m. for discovery status, and then again on September the 8th at 9 a.m. for pretrial. And due to the nature of your charge, I'm ordering you to take a drug test. You're going to go take the test with probation. Also, I'm placing conditions of bond on you based upon the nature of your charge. No alcohol, no drugs not prescribed, no illegal drugs, and no THC or marijuana in any form, no matter where you're at. And so you're going to take that drug test, Mr. St. Clair. We are at the end of the docket, so I'm not going to require you to come back in and report to me. But I'll tell you now, if you test positive, that's your one free shot. I'm going to test you again in August. If you test negative, it's all good, but you're still on those conditions of bond. Do not leave until the probation officer tells you that you are clear to leave, and we will make sure that those drug test results end up in your file. If you test positive today, and then again, the next time you show up, I can't promise you won't go to jail. So if you need help, ask someone. Okay, but everybody gets their one free one in here. So take the test and don't leave until probation tells you you can, and I'll see you in August. Thank you, sir. You too.
That's all I have to this afternoon.
You got to give him copies of those bonds. Don't go anywhere, Mr. St. Clair. You need copies of your bond.
I'm gonna do that. Thank you. Your Honor.
It's an easy way to handle that. Mr. Scott. Mr. Brackens, come on up. Back on the record in cause number CR 21-0454-173, the state of Texas versus Rodney Brackens. Mr. Brackens was arraigned, ordered to take a drug test. He has tested positive for methamphetamine and THC. and admitted that yesterday he smoked marijuana and used ecstasy. Just yesterday.
It's saying June sixth.
Oh, I thought that was a 9. Either way, Mr. Brackens, I'm placing you on conditions of bond, no alcohol, no illegal drugs, no drugs not prescribed, and no THC or marijuana in any form or fashion. If you need help, marijuana, you can stop that. If you need help with that meth, get help. I'd rather have you in treatment than in jail, but I won't hesitate to put you there if you test positive again in August. Okay, for your own good and that of the community. So once you get a copy of those, sir, we'll see you in August.
Okay, good to go, Your Honor.
Yes, sir.
Thank you, Judge. Maybe excused?
Yes, sir.
Good day.
All right, who else are we waiting? What about this Mitchell Roberts? Did we do Mitchell Roberts already? I can't hear you. Oh, okay. Oh, is it Jeff? Okay, that's why. Jeff is? So I'm just missing Felicia Big. Was that Mills? All right, come on up. That's all right. Come on up, ma'am. Yep. This is cause number CR 21-0457 and cause numbers CR 21-0458-173, both styled the state of Texas versus Felicia Big. Ms. Big was arraigned, ordered to take a drug test. She has tested positive for methamphetamine and amphetamine and admitted to smoking it just a couple days ago on the 8th, which means you're probably coming down. So Ms. Big, I'm placing you on conditions of bond, no alcohol, no illegal drugs, no drugs not prescribed, and no marijuana or THC in any form, no matter where you're at. Even if you're in a state where it's legal, it's still against your conditions of bond. And so I'm going to give you a copy of those and make sure you call Mr. Mills, let him know you did test positive. If you need help, get it. I would rather have you in help than in jail. But if you come back in August and test positive, I can't promise which of these doors you'll go out of. I don't want to put you in jail, but I will do so if it protects you and the community. Understand that. All right, get help if you need it. I'll see you back in August. Yes, ma'am. Halsey, so got the- My goal was to try to hit 11:30. And I think we're going to hit it if I knew we had all these cases. Your good luck. We'll be there. I think she's doing a better job than you are, Sandy. I'm just kidding. Mr. Harrington, you ready on anything? Okay. I've got it. I've got both yours. Who do you want to do first? Halsey?
Yes, that'd be fine.
Okay. Are y'all pleading it?
No,
Oh, okay. Sorry. Well, let's go. You can arraign him though, can't you? Sure. All right, let's do that. Come on up, Mr. Halsey. Get you up and down and up and down. You've been sitting here all morning though.
Yes, sir. It's Halse, you don't pronounce the.
Halse?
Yes, sir.
I don't mind at all. When people call me McGee, it drives me crazy. Halse.
Yes, sir.
All right. I can't promise I won't mess it up again the next time, but I'll do my best. All right. This is cause number CR 21-0420-173, the state of Texas versus Stephen Hulse set for arraignment. Mr. Harrington.
You're right. I went up the indictment yesterday with Mr. Harsh, and his name is spelled correctly in it. He understands the charges alleged in the indictment, the way the formal reading indictment and enter a plea of not guilty this time.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. You're receiving 2 new court dates there in writing. That's August the 11th for discovery status, and then again on September the 8th at 9 a.m. for pretrial. So if you do get out of jail between now and then, I need to see you in this courtroom on August the 11th at 9 a.m. Does he have conditions of bond?
He
You know
has,
what?
I'm sorry.
It's okay.
He has standard conditions upon an indictment, but we're gonna ask that the court put him on sex offender conditions.
Okay, granted, then I'm going to put him on those. Now, are we ready on the bond reduction hearing now that Ms. Pace is here?
Yes, Your Honor.
I wasn't going to do it without you. It's going to go ahead and arraign him, and then we were going to wait on you.
Of course. Thank you.
All right, and Mr. Harrington, are we going to hear testimony from your client for the limited purpose of bail?
We are. Your Honor.
All right, sir, if you could raise your right hand the best you can. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can lower your hand. Mr. Harrington.
How do you want to take your name? State your name for the record, please.
Stephen Ray Hulse.
Mr. Holmes, how old gentleman are you? How old are you?
I'm 38 years old.
And I want to ask you a few questions about your family and your ties to the community. Where were you born?
Anaheim, California.
And did you get to Texas as soon as you could?
When I was 12 years old.
So when you got to Texas, where did you live?
Corsicana.
And have you been in either the Henderson County or Nevada County area for the past 26 years?
Yes, I have.
Can you tell me what kind of family relations you have here that reside in that same area?
I have my aunt, my cousins, and my wife, my mother.
Okay, so the majority of your family now live in either Henderson or
Yes,
Nevada
sir.
County.
Yes, sir.
And is your wife here and your aunt and your mother?
Yes, they are.
And how long have you been married?
5 years.
And do you have any children or child?
Yes, I do.
And you tell the court who that is.
Callie Hulse.
How old is she?
She's 11.
And so does your wife work here in the area?
Yes, she does.
And what does she do?
She works for, she's like accountant for Blazing Water Sports.
And your aunt who also is here, she also. And
Yes, she is.
what does she do?
I'm not really sure. I know she's a hard worker. She works.
Okay. And your mom, does she work outside the
My
home?
mom's on Social Security, I believe.
Okay. Now, I want to talk a little bit about your employment history, going back a little ways. In the last 3 or 4 or 5 years, can you tell the court where you were working?
I was working at Galaxy, which is across the street from my house. I was there for 3 years. And then I got better pay offer at FedEx, so I was there
Going back, so how long you worked for Galaxy?
about 3 years.
And what kind of work did you do for them?
I was lead for the electrical department.
And you say right across the street, for the past 7 years, have you been living in Malakoff?
Yes,
Okay. And have you lived in the same residence for the last 7 years?
yes, I have.
And do you own that house or do you rent it?
I rent.
And so you worked there for 3 years and you worked a year for FedEx
Yes.
and you left there because,
The hours got real low.
was that during the pandemic time, I guess, or whatever?
Well, after it, yeah, pretty much.
Okay.
And then I found a better paying job in Corsicana at Guardian Glass.
And did you work there for 3 months as a temp worker?
Yes,
And then right before your arrest, you become a full-time employee?
yes, I was.
And were you making approximately $20 an hour once you became a full-time employee?
Yes, I was.
And how long have you been in jail?
Since May 19th, I believe.
So close to a month, or a little
Yes.
shy of a month. Okay. And your bond is currently $250,000.
Yes, it is.
So you say you lived in the same place for 7 years, is that right?
Yes, sir.
Do you own any real estate of any kind?
No.
Do you own some vehicles?
No, I'm still paying on.
Well, you own some that have a note on them.
Yes, sir.
So they're kind of upside down, as we say.
Yes, sir.
You probably couldn't sell them to anything more than a note.
No,
Okay. Do you have money in the bank or anything like that you could perhaps, or anything you could mortgage to raise money for $250,000 bond?
no,
Now, have you and your family talked to bondsman about trying to close that $250,000 bond?
Yes,
And is the best agreement you have so far would be to come up with $10,000 in cash and then pay out 15,000 remainder over a period of time?
yes.
Or are y'all able to do that, even with the help of you and your family?
Right now, no.
Uh, Now, are you asking the court to reduce your bond today?
Yes,
And do you think with the help of your family and everything, you could perhaps post a $50,000 bond?
yes.
And that would include your aunt. I think she's trying to get a loan from her 401k.
It's just-
Now, when you look at the indictment, these allegations go back 3 or 4 years. That's
Yes.
Looking at the indictment. I don't want to get into the allegations of the indictment, but I do want to ask you one question about it. Law enforcement talked to you about these allegations over 3 years ago.
Yes, they have.
And since that time, you didn't flee, you didn't run, you didn't move, anything like that.
Same address, no, sir.
If you were to be out on who's the bonds?
Bond conditions.
Okay, bond conditions. You understand that if you were out on bond, the court has ordered bond conditions. And we talked about that the other day, that potentially if you were out, the judge would order bond conditions. And you understand that, like, you cannot go within 1,000 feet of where children commonly gather, schools, daycare centers, et cetera. Not have any contact communications by any means of any alleged victim of this offense.
Yes,
Not come within 250 feet of the residence where the alleged victim lives, except you see the rest of them.
yes,
Would you be able to abide by each and every one of those terms?
yes, with no problem at all.
And you understand if you were to violate those terms, what the court would do is file a motion to revoke your bond, put you back in jail, either no bond for a while or at least raise your bond.
I understand that loud and clear.
So what you're asking the court today is to reduce your bond to $50,000 and see if you can make that bond.
Yes, sir.
Okay.
Ms. Pace?
Thank you, Norman. You said you talked to your aunt and your wife about helping you make bond.
Yes.
What about your mother?
She's on Social Security, so she's not much she can do.
How many cousins do you have in the area?
Three.
Were you able to ask them for help at all?
Not yet, but sure, my family, I'm sure they will.
Did you haven't checked
I
with them?
haven't checked with them personally.
You said you worked at was it a glass company before? And how, were you working there right up until you were arrested?
Yes, ma'am.
Okay, and how long did you say you have been working there?
3 months as a temp, and then like as full time as a month.
About 4 months.
Yes, ma'am.
And do you have any, it sounds like you have a decent employment history. Do you have any savings at all from that?
No, I don't. I like to spoil my life, kids, so no, I just
You said you lived in Waybank for 7 years. Is that correct?
yes, ma'am.
Is that still where your wife resides?
Yes, ma'am.
Is that where you were residing before the date of your arrest?
Yes, ma'am.
And is that at 6627 Highway 198?
Yes, ma'am.
And both the named victim in this case and your 11-year-old daughter lived with you previously?
Yes, ma'am.
And so your daughter Callie, she's not 11 years old,
Yes.
you said? Where is she living?
She's living with me. I have full custody. But while I'm in here, her mother went ahead and she has her. So
But if you were to be released, would you?
I would definitely, yes, if I'm able to, yes.
Okay. And she's your biological
She is my
daughter?
biological daughter.
And you
she-
would want her to live with you?
And she would want the same.
And who else would be living?
My wife.
Do your cousins have any children?
Yes. One has like 4, the other one has 2, and the other one has like 4 also.
About how old are those kids? An age range? You don't have to tell me all.
Anywhere from I'd say 2 to 10.
And these are cousins that live locally?
they lived in Navarro. Not here in town. The one living in the county is just me, my wife, and my daughter. In this county. All my rest of my family lives in Navarro.
Mr. Harrington, redirect?
One question, this is asked about your employment. Do you believe that if you were on bond, that you could get your job back with Guardian over in Forest County?
Yes, I already speak to my supervisor and he knows I'm a good worker and he actually gave me vacation time as much as he could while I was in here. So,
So you think if you were on bond, you could,
definitely.
and is that located in Forest County?
That is in Forest County.
I'll pass this judge.
Any further questions from the state, Your Honor? What activity is on this criminal history?
Yes.
Mr. Hulse has a deferred possession of marijuana and driving while license invalid from 2004 and 2007, and then convictions for driving while license invalid, failed to ID, possession of marijuana, and another driving while license invalid.
All misdemeanors?
Yes, Your Honor.
And do you have the probable cause affidavit?
Your Honor, I don't have a probable cause affidavit in this case because when Mr. Hulse was arrested, he was arrested on 2 Class Cs. And then there was no arrest warrant or anything in this case, and then he was indicted. So when he was arrested on those Class Cs, they interviewed him at the jail on this offense. So I have an offense report, but I do not have any affidavit for the court to review.
What was that from 3 years ago? I'm not trying to get.
It was February of 2019
Okay.
when they interviewed him at the jail. So I have that if the court would like to review the offense report, but
Can I see the indictment? So let me get this straight. So in 2019, he's interviewed about these. Is there a CAC or anything?
there is, Your Honor. So the report is made and there's a CAC, and I guess law enforcement decided since he has these warrants, they'll arrest him on those. And at that time, they interviewed him. It all happened around the same time.
Yeah, we were the judges. So that's when we kind of were the allegations 3 years ago. We were speaking. I assume if there was a recent one or not. I don't know.
Do you mind if I look at the offense report?
That's fine.
Fairly long, but I think a lot of the information is.
Is there a CPS case as well?
Judge, there has been some litigation. I don't think CPS was involved. There's some litigation even back then.
Family.
I think over at the 3rd District Court perhaps. My understanding what happened there was when this came up that there was a hearing 2 weeks later. Basically, Callie went back home and has been there ever since. With her father, the one, I'll use your name, the one that made the accusations, I believe went with her mother at that time.
Okay.
And there's been absolutely no contact at all between Mr. Holmes and the child. She was the mother of both children. And he was
Got
the only father of Callie.
Okay.
So,
Yeah. I was given custody of both, even though I wasn't the father, and until these accusations came up.
yeah, I think it was resolved shortly after, sometime in spring 2019.
Right, and what is the bond now?
It's $250,000.
And so to get this straight with the kids, I mean, so these are allegations from just one teenage girl, is that correct? Not the other. And both were cacked,
Yes. Your Honor.
and one said nothing and the other made the accusations.
That's
Okay. And there's family law litigation, and sorry.
There is, Judge. There was some back in 2019. I don't think CPS was involved. I think it's just more between the parties, if I'm not mistaken, but I think there may be some, this may have stirred up more family law litigation at this point.
I'm surprised it's not CPS, because I would think law enforcement would have a duty to report it. And that's kind of unusual.
Well, they might have, yeah.
There you go.
I
Okay.
don't have the
All right.
records,
Well,
Your Honor,
okay.
yet, But I would suspect that CPS has been involved.
So there are, if I do reduce the bond and he gets out, there will be no contact, right? I mean, what I'm saying, she's not in the house. I can order no contact, but she's not already in the house.
My understanding, he has not seen her since February 2019.
The complaining witness, what about the other daughter?
Well, she was living with him, yes,
Okay, but she's with her mother now?
but based upon this arrest. yes.
Okay. Well, then, court, anything else?
Well, Your Honor, I just want the court to know that the state is very concerned about the 11-year-old living in the home, Mr. Hulse.
I am too.
For this pending, she is at the age now that the complaining victim was around the age of when these allegations.
Right, but she didn't make any
She
allegations.
didn't make any allegations.
Anything else to close?
No, I think at this point, I think she's with a mother. At this
Right.
point. I think there's litigation maybe next week on that issue.
Right, well, then the court then, based upon the testimony, the evidence and arguments, reduces bond to $100,000 surety bond. There will be no children residing in the home. In addition to these bond conditions, any contact that he has with his he'll have no contact with the complaining witness. Any contact that he has with his biological daughter will be supervised by the biological daughter's mother,
Yes, sir.
which is where she's living now, right? Is that correct?
That's correct, Your Honor, my understanding.
So no contact unless mother is physically present during a visit. Biological mother.
Thank you.
I think it just happened all.
Right. Can we add that? No
I'm gonna add a
contact
condition.
with biological daughter
Of course.
unless physically supervised by biological mother. What else do we have here? Ms. Bennett, you need to see me? Okay. Oh, you're fine. I'm not dressed appropriately half the time anyway.
This is your Polaroid stuff,
Okay.
and there's two of them. One of them is the video, and one of them is the paper. That yellow number is what you read.
Okay.
Your numbers, your,
And do I owe you anything?
no, you get to be free because you're a judge.
I love to hear the word free. Thank you, ma'am.
Thank you, Judge.
No, just basically, you put $100,000.
Okay. And then the other condition will be in there.
Yes, and I'll go back and explain that to him again. just to make
Okay.
sure he understands.
Up right here. Taking Bill of Rights, CLE, looked pretty good. What's that?
I asked earlier why Dawn was here. Ron Bob just told me she was going to give you a rights.
Thank you. Oh, I've already signed it. Okay. All right. I hope you take those bond conditions very seriously if you do bond out, sir, because I do.
I'm not talking about that, Judge.
And do we have, and I already gave him his reset notices, so.
Yes, sir.
Okay. And that'll be an arraignment. Two girls, one day, one day. And you ready for arraignment on the other?
Yes, sir.
Mitchell Roberts. He's still here. He was here earlier. Right? Fill out the paperwork. We'll do the same thing. Mr. Roberts, come on up, sir. This is Mr. Harrington. I don't know, do you need to talk to him just for 1 second?
No, we're ready to-
Okay. Do something I did last week. All right, this is cause number CR 21-0446-173, the state of Texas versus Mitchell Roberts. Set for arraignment, Mr. Harrington.
Mr. Roberts has reviewed the indictment. His name is spelled correctly. He understands the criminal little offense alleged in the indictment. The way the formal reading indictment, he must plead not guilty to the alleged offense and not true to two enhancement paragraphs.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates are August the 11th at 9 a.m. for discovery status and September the 8th at 9 a.m. for pretrial. And so I will see you back on August the 11th at 9 a.m. Now, I am ordering you to take a drug test today. You're going to go take the test. Do not leave until probation tells you you can leave. You don't have to come back in front of me, but you can leave after you take the test and we have the results. Based upon your charge, I'm placing you on conditions of bond. No alcohol, no drugs not prescribed, no illegal drugs, and no THC or marijuana, no matter where you may be or in what form it may come in. Now, the way it works is if you test positive, that's your one free chance you get in the court. The next time we'll have a hearing and you may not, you may go to jail. You understand that if you test positive again. Now, if you test negative, everything's fine, but we will go over your results when you come back in August, okay? If you need help, if you do test positive and you need help, find it. I'd rather have you in rehab than in jail, but I won't hesitate to put you there. So take the test. When probation tells you you can go, you can go. We will go over your results in August.
Thank you, Judge. I'm going to talk to him about.
Yes, sir. Uh-huh. Anything else? Gosh, Kevin, that was easy. What else you got? Yes. I was hoping All right, good afternoon, ladies and gentlemen. Here in just a few minutes, we're going to take open announcements on the 1:30 docket. We have a number of cases on today's docket, so I'll move as quickly as we can. So if we can have things ready when I call them, or as quickly as possible, and do us a favor. If you're appearing via Zoom, please keep your microphone muted until it's your turn to talk or until your case is called. Also, if you do not click the stop video button, we can see what you're doing. So if you wouldn't do it in a courtroom, please don't do it on Zoom. For those of you in the audience, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. I'm not going to make your health decision for you. So that being said, I'll take open announcements. Mr. Files.
Good afternoon, Your Honor. The first thing we have is a substitution of counsel on Mr. Reed. He was being shown from Anderson.
What page is it? What page is it on?
Page 1, 1, 2, 3. Yeah, 3 over here. He also has cases in Anderson County. I think he's been
Which
returned
page?
to
Which
Anderson
page?
County.
Oh, I see it. All right, these are cause numbers CR 20-0361 and 0362-173, both styled the state of Texas versus Jedediah Reed, and handle the substitution of counsel first. I signed them yesterday, so I guess I got those signed.
We also filed motions for continuance since we're just now
Yes, sir.
getting in the case.
Any objection?
No, Your Honor, and there was a third call number. I'm not sure if you called the 0360.
Oh, there it is. Yeah, in CR 20-0360. Gotcha.
No objection, Your Honor.
All right, granted. And so how much time do you need since you just got on the case, Mr. Files?
Since we just got in the case, I think there are a total of 8 or 9 cases pending in the 2 counties. So it'll take us some time to get a handle on what's there and see whether or not we're going to have trials or have it resolved. I would guess at least 60 days.
All right, here's what I'm going to do. I'm going to set this. What do you got in August? What I'll do is I'll set it for pretrial August 12th at 1:30. But if you have issues with discovery or something, just let me know then.
State's being cooperative, is always on discovery. If we have something we need to bring to the attention of the court before then, we will.
Thank you, sir.
Your Honor, we've already turned over all discovery.
Okay.
Very efficient as always.
And you have, as soon as you receive that reset notice, Mr. Reed, you can have a seat. And then you have Jefferson Allen, Mr. Files.
I'm sorry, Your Honor.
Jefferson Allen.
Mr. Allen is here. This is a status conference. We can report to the court that we've had.
Well, let me call it and call it up first. This is cause number CR 19-0693-173, the state of Texas versus Jefferson Allen. Mr. Allen, come on up. All right, set for trial docket status. I'm sorry, Mr. Files, go ahead.
We have an expert who has done some work for us since the last appearance before the court. However, we do not have a written report. The state a moment ago tells us that there are 2 other indictments pending in the other court, and we do not know anything except for that, and I will yield to the state.
Your Honor, and let me clarify, we have taken this case back to grand jury for additional indictments, and that is Judge Calhoun's grand jury as well. So, Mr. Files.
Have they got indictments yet, or is it just been?
They went to grand jury last week, but no cause numbers have been given and no warrants have been set on those.
Okay. Well, then why don't I reset this then? August 12th, 1:30, since you'll be here on that other case, Mr. Files.
Sounds good, Your Honor.
All righty. Well, then we'll see you August 12th. If we have to have an arraignment, are we going to do it that day? On new cases? Okay. So if there has been indictments returned, once they're assigned cause numbers, we'll just handle the arraignments on that same day.
I may have misunderstood. I thought they were going to be Judge Calhoun's court.
I'm sorry, it's Judge Calhoun's grand jury.
This is grand jury, so I haven't set the bonds on them, so I don't know anything about it.
Over here, do we go to 2 different judges, or do you all consolidate and go to the first judge?
No, it'd come here.
So
We try to keep cases in the same court.
While we're here and discussing it, Mr. Allen today again drove 10 hours to be here. He's been doing the same thing here. He's been in attendance on court in Anderson County. We would hope that the court would basically continue him on these same bonds without additional.
I'm not it's his grand jury, not mine, so I don't know what he'll do with bonds.
I misunderstood. I thought he was at the bond and the cases would come here.
They would. But I mean, I can't tell you I'll set the same bond because I don't know what he'll do.
I understand. If we have a motion after the bonds are said, we file it in that court, or we file it in this court since it's coming here.
Following his, well, it'll come here, so file in this court.
In this court.
Yes, sir.
And that's all the business we have before the court. May we be excused?
Yes, sir. Good to see you.
Thank you. Oh, we just got back from DC on our case up there. DC is a ghost town. It is, everything is fenced off. It's remarkable.
Wow.
And nobody moves without a mask.
Different world.
Different
Good to
world.
see you, Mr. Fowles.
Judge, Your Honor.
Jimmy Marshall. I'm ordering you to take a drug test. Go take the test. When you get done, come back in the courtroom. We'll go over the results together. All right, continuing on with open announcements. Ms. Thompson, you next.
7, Your Honor, Loretta Davis.
What's she on Zoom? Oh, okay. Miss Davis, I got you right here.
Yes, sir.
All right, this is cause number CR 20-0383-173, the state of Texas versus Lorinda Davis. And this is set for status. Now, where is Miss Davis?
She's in a place called Solar Living in Houston, Texas, Your Honor.
Okay. All right, and this is set for status. Where are we at?
I'm sorry, I think I said solar. It's Solar Living.
I'm sorry.
Okay, we're also here on a motion to withdraw, Your Honor.
Let's handle the motion to withdraw first. I don't have that on my docket.
It was filed on 5/17, Your Honor.
Okay, all right, we'll go ahead with your motion.
Ms. Davis, the last time we were in court, expressed that she didn't want me to represent her any full.
I can't hear anything.
She basically called me a liar on the video. At that demand, I filed the motion to withdraw, Your Honor.
All right, do you hear that, Miss Davis?
No, no, sir, I'm having some trouble with audio. Could you just give me one moment? I'm sorry. Yeah. I apologize. I know.
Can you hear us now?
Yes. Yes, okay, yes, sir.
All right, Ms. Thompson's filed a motion to withdraw because you called her a liar. What do you want me to do?
Yes, sir, she wants, yes, she can withdraw.
Okay, well, that motion's denied, then let's move on with status.
Okay.
Y'all gonna have to learn to get along. You're down there. It's kind of hard for y'all to talk, but I appreciate you being there because it sounds like that's where you need to be. So
Yes,
get
sir.
yourself straight, and then maybe you and Ms. Thompson could see eye to eye. And so status.
Your Honor, there's a little bit more to it than that that I would like to have on the record.
Go ahead and put it on the record.
Ms. Davis and I have spoken together in the past. I have met with Ms. Davis. The state made an offer of safety, and what she was told about safety, she called me, demanded to know more information about the facility itself. And I expressed to her that I didn't know anything about the facility, that it would depend on which one had a bed open as to which one she would go to. She immediately told me, says, I'm hanging up on you. And she hung up on me. And when I tried to call back, it just rang. She had refused to give me an address where she could be found and simply told me she was living in Dallas for health issues. I then called Farmers Bill Bonds. They provided me with the last known address for her in Grand Prairie. I sent her a letter to that address with safety program information. Also, on December 28th, sent her a letter stating that my phone number had changed, which she told this court that she couldn't contact me in any way. She did have my phone number sent to the last known address. She also could have called the bail bondsman and gotten that information. She also could have called Ms. Padron and gotten that information. There's been no contact. The last time we were in court, here the court made her write my phone number down. She still has not contacted me, Your Honor, although I sent her a letter.
Ms. Davis, how much longer are you in that rehab facility?
I have 5 more months, or a little less than 5 months, sir. I just got promoted and transferred to a different facility. I
Okay.
got put on staff.
Well, I'll keep the motion pending until we can figure out what we're going to do with your case. Ms. Thompson, being on the list, sometimes you have to have difficult clients, and she's in rehab. She's gone through a lot. And I appreciate your story, but
I understand.
Either way.
It's just hard to prepare for trial when you have no.
I'm not
contact.
setting it for trial, but
We want to do a reset date, Judge.
let's reset this sometime in August. When did we reset those others? August the 12th. I'm going to reset them for,
Write it down.
well, do we have anything in September? Where did Kevin go?
What's that?
We got a setting in September. Yeah.
September 14th, 1:30.
September 14th at 1:30. Ms. Davis,
Nice. Jane,
I'm going to order you as a condition of bond to respond to your attorney's calls and her letters. You understand me?
yes, sir, I'm available.
Okay.
I have the same phone number. Yes,
All right.
Would you also ask her, Your Honor, to provide the current address where she is now?
Where's the address that you're at now, Ms. Davis?
I have a permanent address that I've always had, but
Not the one you always had, where you're at now.
right now I'm at 1919 Tarrant. She sent a letter there. She has that address, sir.
Just
I
give me
was-
the address, Ms. Davis.
1919 Tarrant Drive, Houston, Grand Prairie, Texas. Sorry,
Houston, Grand
19
Prairie, Galveston, Texas. Which is it?
Grand Prairie, Texas.
You're in Grand Prairie?
Yes, I just got transferred
Okay, Grand
from
Prairie.
Houston.
I don't have that address. And I didn't understand.
That's okay. Look, we're bogging it down. I got a whole bunch of people waiting. What is the zip code?
75050.
1919 Tarrant Drive, Grand Prairie, Texas, 75050.
Correct.
There we go.
All right.
Problem solved. Thank you, ma'am. You're free to log
914
off.
130. Thank you, sir.
Thank you, Your Honor.
Yes, ma'am.
Have an excuse, Your
Yes, ma'am. Thank you. Mr. Stevens.
Page 6, and we can mark down the docket.
Coach,
I just looked up that address on Google Maps. It's not a rehab facility. It's an apartment.
well, read the purpose.
File a motion.
Well, I didn't understand.
It looked like a shower curtain behind her, but I wasn't going to say anything. I was giving her the benefit of the doubt. Thought there was kind of a bathroom echo. Mr. Stevens.
Page 6, Your Honor. We can work out the docket. Like Jesse Bailey, maybe.
Are you here on, oh no, Bill's behind you. Okay, Jesse Bailey. Maybe she was just promoted to an apartment. I mean, you never know. It's like a halfway house. You haven't been benefit of that. All right, this is cause number CR 20-0711-173, the state of Texas versus Jesse Bailey, and that is set for status. Where are we at?
Your Honor, it is set for status. However, I filed a motion suggesting a competency. I received a phone call from some of his cellmates that indicated that he had fallen and hit his head, went to the hospital. When he came back, he did not know that he was married, who his children were. Obviously had no idea why he was in jail or who I was as his attorney. I did do a Zoom jail visit with him just recently. He still does not recall who I am or who his family members are. Based on that information I just received, I would ask the court to order a competency evaluation.
The state's not opposed to that evaluation. We've done a little digging and we're not able to find any incidents of injury. That doesn't mean it didn't happen.
Well, there
but
would have been an incident report filed from a DSO in the jail if that did happen.
We looked for that and did not find that.
And he was.
And I will say this, I assumed he went to the hospital. He may not have gone to the hospital. I just received a call from inmates saying he had fallen and hit his head. So I assumed he went to the hospital, but He may or may not, but I would assume there'd still be some kind of incident report where he would have met with at least the medical staff there at the jail.
I don't know anything about this.
And he indicates to me he didn't remember the incident, so there's not much I can question him on that, other than he doesn't, I assume, still know who I am.
And you don't oppose it? All right, then I'll grant it. And let's see,
There's an order that we e-filed, but I left. the
I got it
docket
right
blank.
here.
Okay.
Well, certainly if the state can test competency after evaluation, you could always subpoena those folks that had called Mr. Stevens. All right, who are we going to order? And when do we want to set this for a hearing? It's going to take some time. How about August? All right, then court's granting them the motion to have the defendant evaluated for competency and resetting this for August the 12th at 1:30. You can have a seat, sir. How long has he been in jail? How long you been in jail, sir?
Well, I do, sir.
Okay.
Believe it. I mean,
Now, if he could tell me the date, I thought maybe that'd be different. If he'd have turned around and said 478 days, it would have made a difference. Who else you got?
We can work down the list, Your Honor. I'm ready on all of it.
Willie Davis. Never know. It's cause number CR 20-0674-173, the state of Texas versus Willie Davis, set for status.
Your Honor, we are set for status. I do think we'll probably most likely have this worked out. To my understanding, the state reached out to the victim in this case. I don't have any issues. If we want to place it on the trial docket, what the court will give us leave to resolve it, or the court can set another status, whichever the court prefers.
Real close.
My preference, Judge, is to set it for another status. If Mr. Stevens has presented me with a couple options, some counter offers to resolve this case. I have reached out to the victim. The first time I tried, there was no answer. The voicemail was full. Tried yesterday. I was at least able to leave a voicemail this time.
Where is it?
I'm sorry?
What church is it?
It's not a church.
Says
Habitation or church.
Oh, I just said, worship. Okay, gotcha.
If we could have one more status, Judge, we'll have it resolved with one more status, I think.
July 15th, 1:30. Mr. Davis, you're in jail. You're all right with that?
Yes, sir.
All right, I'll see you July 15th at 1:30. Yes, sir. Brenton Persinger. This is cause number CR 20-0712-173, the state of Texas versus Brenton Persinger, set for status.
Your Honor, it is set for status. We'd ask to place it on trial docket.
Is there an offer?
yes, Your Honor, 8 years to DC, 230.
And is that offer being declined?
Yes, sir.
All right, then the court will note that and sets this on the trial docket. Do we have how long has he been in jail?
233 days.
So what would that put him? Number 5.
He would be number 5 for July.
Okay, so what's the date on that announcement?
One other vacation notice on file, 25th to the 31st of July. File that week.
Trial will be July 12th.
July 12th, 9 a.m. for announcement for jury trial on July the 19th, jury selection at 8:30 a.m. And may I see the indictment? Thank you, ma'am. Are these cases that can be stacked?
They are, Your Honor.
Okay, so he's got how many counts?
I believe it's 8.
All right, so there's 8 third-degree felonies, and so Mr. Persinger, and I know that Mr. Stevens has explained this to you. But, you know, if for some reason you were convicted by a jury beyond a reasonable doubt, and there was a request to stack, the court could stack these sentences. So in other words, if you got, for example, 10 years on all 8, the court could what we call stack those, and you would have to do them one after another after another. You understand that? And I'm sure he's explained that to you. I just want to make sure you understand. All right, we'll see you for announcement on July the 12th. Have a seat, sir.
That would conclude my business.
Yes, sir. Appreciate it. Mr. Bill Stevens.
What do you want, Judge?
Let's do it this way. We got one in jail first, Mr. Yeager. Or Miss Yeager, sorry. Come on up, Miss Yeager. This is cause number CR 20-0488-173, the state of Texas versus Teora Yeager. Is it Jager or Yeager? No, what do you want? Jager, all right. All right, and set for status, Mr. Stevens.
Judge, we signed a waiver of jury and we're going to ask for a plea date. We
Okay.
haven't worked out. I just can't plead it today because of my schedule. I've got people at my office for trial prep for next week.
All right, well, then I need to put her under oath. Ma'am, if you can raise your right hand best you can. Do you solemnly swear or affirm the testimony you're about to give now on trial will be, I'm sorry, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Ms. Jager, I'm showing you this waiver of jury. Does that look familiar to you? And did you go over that with Mr. Stevens?
Yes, sir.
And I'm sure he explained some things to you, but I'm going to explain them. You know that the Constitution of the United States and this state basically hold that you are entitled to a jury trial. Do you understand that?
Yes, sir.
And the only person that can waive that is you,
Yes, sir.
not your attorney, not me, not the state. Only you can waive that right.
Yes, sir.
Right? And if for some reason you waive this and I accept it, and then you back out of this deal or something falls through between you and the state, you would no longer be entitled to a jury trial. Do you understand that? And you'd still be entitled to a trial, but it'd be before the court and not a jury. Do you understand that?
Yes, sir.
And do you want to continue on with this?
Yes, sir.
All right. And Mr. Stevens, do you believe your client knowingly, intelligently, and voluntarily entered into this waiver?
Yes, sir, she
And
did.
the court finds that she does. Further finds that the state has consented, and I'm approving it this the 10th day of June, 2021. And when are we resetting this for a plea? July 15th at 1:30. Is it for time? Okay.
Yes, sir. It
As
works.
soon as you have your reset notice, ma'am, you can have a seat. Let's see, moving on to Kenneth Bone. May I see the docket sheet? This is cause number CR 20-0017-173, the state of Texas versus Kenneth Bone. And that is set for trial docket status. Where are we at?
Judge, we have not reached an agreement with the state. The state did make an offer, a 5-year offer. I think he's probably 25 to life eligible. Mr. Bone has rejected that offer at this time.
All right, the court notes that the offer's been rejected, and we will set this on the trial docket. He's not in jail.
No, sir.
Oh, there's another one, CR 20, you didn't little squiggly line there. CR 20-0690-173. And that offer was to wrap them both up?
Yes, sir.
Yes, sir.
Okay. All right. Do we have a date for him, or is he too far down? All right, Mr. Bone, basically, I'm not going to give you a reset date now. However, you are still on bond. And so once your case gets closer to the top, you'll receive notice of when to show up for announcement. You're still on conditions of bond, therefore I'm ordering you to take a drug test today. You'll go with probation, take the test, don't leave until we talk again.
Yeah.
All righty, sir. Thank you. I think that's everybody of yours, Bill. Anything else?
No, Judge. I'm
All
sorry.
right, thank you. Mr. Head.
All right, starting on top of the grade, Cameron Elder. Your Honor, it is, he is filling out all the paperwork for the PTI application. I spoke with him. He was gonna try to come in before the date. He's been working 10 to 12-hour days, just hasn't been able to get in to see me. So we've already waived the jury. We're just asking for maybe about 2 weeks for the.
So we've already done, I've already admonished him. on
You
jury.
have.
Okay, is he here?
Mr. Elder?
I'll just call it to reset it. This is cause number CR 20-0371-173, the state of Texas versus Cameron Elder. And let's see, y'all want to reset this on the PTI? Are y'all doing that in front of me?
We have been.
Okay, I just don't know. I guess we have. So he's already waived a jury, so I'll just set this for July 15th, 1:30. I guess with the PTI, they still have to do it here. I mean, what are we gonna do when we do it here? He's already waived a jury. I mean, what,
For admonishments on.
that's what I'm gonna do. I'm gonna set it for July 15th at 1:30, but if y'all have already done the contract and all, Mike, if you can just call Kevin and we'll pull it off the docket.
Yes, sir.
Okay. So Mr. Elder, I may or may not see you on the 15th. If you don't hear from your attorney, I'll see you on July 15th at 1:30. And if it's already taken care of, we'll pull it off the docket. Yes, sir.
And, Gunner Damian Williams in custody.
Mr. Williams, come on up. This is cause number CR 20-0253-173, the state of Texas versus Damian Williams, set for status.
Your Honor, we have not been able to reach any sort of agreement on this case. We anticipate that it, in all likelihood, will require a trial. And speaking with the state, I think probably, after the first of the year, it's probably our best bet to get a setting. But if we could maybe get just a kind of a trial announcement mid-fall, just so we can touch base with the court and see where we are on things.
We did, Judge, we formally made a 50-year offer.
5-0.
Yes, sir.
And was the victim's family on board with that?
They've been notified and they're accepting that offer.
Okay.
We had discussed early 2022. Last I heard from Mr. Hensley, he didn't have any dates yet for early 2022, but we'd like to get maybe January or February, if that's okay with the court, Mr. Head.
Certainly fine with us, whatever that.
If, where would he be as far as days in jail on the trial docket? We've got special settings in front of them. Okay. Well, and more than likely, once we draft that, and the problem is, as y'all know, with COVID, I mean, I don't even know what the Supreme Court's going to do next week. We're still operating under some plan that we can't even have a jury trial unless we pick the jury over at the Texan, which is no longer available. So that's why we don't have anything yet. We're still, I don't know. I wish I could tell you more because no one deserves this. It's just the way it is. So we'll, you got something in the fall when we will have a schedule? Let's say September. Let's do September. Let's do a September setting.
I'm just gonna call it status.
Yeah, I'm gonna
That's okay.
reset it for status. September 9th at 1:30. So Mr. Williams, we'll see you back September 9th at 1:30. I want to give you a trial, sir, but my hands are tied.
And, Your Honor, Michael Welsh.
Michael Welsh. This is CR 18-0775-3, the state of Texas versus Michael Welsh, set for trial docket status.
Your Honor, there's not an offer at this time. This is gonna need to go on the trial docket.
That's my understanding, Your Honor, and apparently there was a subsequent DNA analysis that has been put in the portal. I was not aware of it, haven't seen it yet, but I think, based on that, there's not obviously we'll need a trial setting.
Well, you haven't looked at the DNA.
I have not.
Is it a DNA report?
It is, Your Honor, and the state's not
Would the state consider it exculpatory or inculpatory?
exculpatory. Yes,
Exculpatory?
Your Honor. And the state's not opposed to discussing an offer.
Let's just set it for a status. How about next month? July 15th, 1:30. Is that all right with you, Mike?
Yes, sir.
All right. And Mr. Welsh, that'll give you an opportunity for your attorney to look at it, discuss it with the state and talk to you. Okay. So July 15th, 1:30. Remember any conditions of bond that you're on? You're free to go.
Then, Your Honor, I had one other one, but I just need to do a little work on
Sure.
that first.
Yes, sir. Move real fast. Cut me some slack. Mr. Schmidt,
Your Honor, page 5, Casey Welsh.
I figure you may have a law partner with you today.
Oh, Jerry?
Yeah.
He was cleaning, you see me earlier?
Yeah, I saw you.
He wouldn't, I had to rush over here and didn't have time to get him in front of the TV and
Okay.
settle and sneak out, so he's over there.
It's Stacy Welsh.
Yes, sir.
All right, CR 19-0135-173, the state of Texas versus Tacey Welsh, set for trial docket status.
Your Honor, I've been discussing this with Mr. Schmidt, and we believe it might be appropriate to wait until Mr. Welch's cases are resolved before we address this. But we believe we might be able to come to a resolution on this.
Well, where are Mr. Welsh's cases?
They're the ones you just called, Your Honor, that we reset for status next month
Oh,
with a new
okay.
lab report.
Judge, and that is our understanding.
How about status for July 15th at 1:30?
So here's the thing. I don't want to go too much into details, but her cases won't resolve until his case is resolved by trial or by plea or by dismissal.
Or by her being on trial, but he's in jail. No,
Well, I mean,
no, he's not in jail.
she's not a co-defendant, Judge. It's a different, I don't want to get into the facts, but I just don't see this going to trial.
I can imagine the facts.
And so, we can set it every month, but she ends up having to, she has her kids and I mean, if you want us to come back July 15th, we'll be here whenever, Judge. It's just, we'll be in the same spot until Mr. Head's cases are resolved, because the facts of this case are not going to change.
I agree with that, Your Honor. I'm not opposed to setting it further in the future.
And we set it in August since his is set in July. 12th, 1:30 or 9? August 12th, 1:30 for status. It's going to back it up to status.
May she be excused, Judge?
Yes, sir.
Thank you.
Thank you.
Jimmy Marshall.
We can do him. That's fine.
Jimmy Marshall. All right, these are cause, or this is cause number CR 20-0027-173, the state of Texas versus Jimmy Marshall. And that is set for status. Where are we at?
Judge, Mr. Marshall was checking with his union rep to see what he could or couldn't take, because he works for the U.S. Postal Service.
Right.
He informed me today that his union rep indicated he thinks a deferred would be okay. But I just received this information today. The last offer, because the last offer was made by Mr. Dickens, and that is not Mr. Cox's fault. That's because I've been asking them to hold off on an offer until I can find out from my client what he can or can't take. And so we think we can resolve these cases, but we need to sit down. We also understand what else is about to
I don't know, but it seems like back in April, we were talking about, no, that was back in May, a month ago, we were talking about he was going to talk to his union rep. And I remember telling him, you might ought to get on the phone and call him. And he just now telling you today. You know who the best co-counsel is, for lack of a better term, in a case? In a criminal case? The best assistant that the defense attorney can have. His own client or her own client. You're his best assistant. And I told you back in May, you might ought to check on that and get with your lawyer, and you're just telling him that today. So it doesn't help move your case. Remember that you're his best assistant in your case. So, all right, well then what I'll do is, y'all want me to reset this to July?
Yes, Your Honor.
And I'm going to reset this to July 15th at 1:30. Now, moving on, Mr. Marshall was ordered to take a drug test. He took the test and apparently has tested positive methamphetamine and amphetamine and denied use. However, this is his second positive test in just a couple months. And so what is his bond currently at? All right, Mr. Marshall, I'm finding your bond insufficient. Your bond is now set at $17,000 surety bond. So have a seat in the jury box. Remember that advice I gave you.
Yes, I do. Taylor Baker, Your Honor.
Mr. Baker, Taylor Baker. Or Miss Baker, sorry. All right, this is cause number CR 20-0651-173, the state of Texas versus Taylor Baker. And that is set for pretrial. Any pretrial from the state?
Mr. Standard motion for discovery, Judge.
No objection.
Granted. And on behalf of Miss Baker? Can I see the indictment?
No, Your Honor, I intend to file a motion for discovery if it went to trial, but just for the physicians. The state has subpoenaed some records, medical records, Judge, and I don't think they've received those yet, but we don't need another pretrial. So I talked to Mr. Cox about just setting for status.
Okay. All right, well, then the court will deem pretrial is held, and Ms. Baker, your next court date is status, and that will be July 15th at 1:30, and status is typically your last day to resolve your case before it ends up on the trial docket, okay? All right, as soon as you receive the reset notice, you're free to go. She like a black belt karate expert or something?
I'm sorry?
That's read the indictment. She like a karate expert or something?
So says the complainant. That'd be excused.
Yes, sir. See, Ms. Altier. All right, this is cause number CR 20-0626-173, the state of Texas versus Dennis Black, set for status.
Judge, I think we're at an impasse at this point. It's not a matter of punishment, it's a matter of guilt, innocence.
Well, he's
So-
presumed innocent as he stands there.
Right, so it's gonna have to go on a trial docket, Your Honor.
Hard to feel that way when you're in jail, though, isn't it? But you're presumed innocent. All right, well, then the court, what's the offer?
I don't recall, Judge, but again, it's
20 years.
okay.
Okay. All right, well, then the court deems status is held, notes that the offer has been rejected, and Mr. Black has been in jail for how long? How long you been in jail, Mr. Black? Five and six. Okay, so he's up.
Probably
to-
gonna be for next trial week in July. He's probably gonna be right on the outside.
Okay,
Possibility of getting
so let's give him a trial docket status. When's the announcement on that one? You just gave me that, didn't you? The 12th and the 19th?
July 12th, 9 o'clock for jury trial announcement and 19th for jury trial.
All right, so Mr. Black's good chance your case could reach the top. So July 12th at 9 a.m. for announcement. And then if your case is number one, July 19th at 8:30 a.m. for jury selection. Right. This one. It's more. Casey Lumpkin. This is cause number CR 20-0553-173, the state of Texas versus Casey Lumpkin, set for status.
Your Honor, we are working this out by Mr. Lumpkin paying restitution in exchange for dismissal. He's made a partial payment today, and he should have the rest of it by the end of the day.
How much money are we talking about here?
So he's going to try to.
It's $2,100 in my Georgia public school system math. Is that right? 3,500, he's made
So
1,400.
he's going to try to get to his bank and get a money order and bring it back by 5. In the event that he doesn't, perhaps we should, do you have any court settings next week or, I mean, or whenever?
16. I know the 16th is pretty full.
I think they'll be dismissing it if he gets it. Not really set. I'll have to take.
That's fine. You want to do next week?
16th is not.
June 16th, 9 o'clock. So you already got the court coordinator sweating. So if you can get it today, it'd help you out. June 16th. June 16th, 9 o'clock. And if y'all present a dismissal before then we'll take it off the docket.
He won't need to be here if he gets that paid.
Right. See, if there's a dismissal, then he won't need to be here.
And that's all I have except.
Yes, ma'am. Thank you. Ms. Fallhaber.
Shannon Brown on page 2, please.
Shanna Brown. See the indictment. This is cause number CR 20-0605-173, the state of Texas versus Shanna Brown. And that is set for status. Where are we at?
Judge, earlier I had made an offer. However, a couple of weeks ago, I had emailed Ms. Fallhaber and told her to disregard that offer because recently there are 2 new cases.
Oh,
So I'm hoping that we can wait till we get those cases in and then look at them globally and try to make an offer to resolve all 4 cases.
can I see the indictment or the docket sheet? I'm sorry. Oh, she's the one who went with the water the last time. All right, well then what I'll do is I'm going to reset status to July the 15th at 1:30. Are those cases in the DA's office yet?
No, Your Honor.
So what are the alleged offense dates? Do you know? I mean, it's not like exactly, but it's just a couple
It
weeks.
was like May.
It was right after Mother's Day.
Okay. All right. Well, then I'll reset status to July 15th at 1:30. It's Brown. You know the drill. I'm ordering you to take a drug test today. When you get done, don't leave. And don't leave the building.
I got it.
Don't leave the building. So take the drug test. When you get done, come back in and we'll talk about it. You got an order for the drug test?
No, I'll get one.
Okay.
And I'm not ready on my other two cases yet.
Okay. Mr. Weiner.
Yes, Your Honor, page 8, Tegan Poindexter. Ms. Curry is on Zoom.
Oh,
But my
okay.
client is present and we have a pretrial intervention contract.
All right, Ms. Curry, you got us?
Yes, Your Honor.
Okay, all right, this is cause number CR 20-0457-173, the state of Texas versus Tegan Poindexter. And this is set for a plea today, but you'll have a PTI worked out.
That's correct, Judge.
And does he have a waiver of jury?
That's part of the pretrial intervention contract that we've waived a right to a jury trial, stipulates the admissibility of a document, the stipulation of evidence that he's guilty of the offense alleged.
Do you have that waiver of jury?
I don't have a specific document for that.
We need a document. We need the waiver of jury. Can y'all do a waiver of jury on him?
It is one of the terms that he signed.
I know
but if you
that's
want-
kind of how we're doing it.
No, I understand.
It's all new to me, this PTI stuff.
Sure,
So
sure.
what we do is bring him up, I admonish him on his waiver of a jury right.
Sure.
Tell him if it falls through, what can happen, and then we go from there.
Right, we'll get that.
Do you want to circle around?
Yes, while they're getting that, I
Okay.
can knock a couple of those out, if that's okay.
Sure. All right, we'll get back with you, Ms. Curry. Appreciate it.
Thank you, Judge.
Page 7, Sarah Connolly.
I know, we're still trying to figure out a process for this. waiver of jury.
Yeah, that's why I explained to them that we're not used to it on felonies. So,
Sarah Connolly.
oh, sorry, we're not, I guess, still trying to get her sworn, so.
I'm sorry.
I don't think they're ready. Don't have her sworn yet. Third time's a charm. Jacob
You can have a
Boudreaux,
seat.
page
We're gonna
7.
call somebody else.
Sorry, I didn't mean to rush you.
She can get mean.
I
Watch
don't
out.
believe it.
Isn't that right? She can get mean. All right, these are cause numbers. CR 20-0594. What? That's the wrong one. CR 20-0594-173 and CR 20-0085-173. Both styled the state of Texas versus Jacob Kyle Boudreaux. And the 0594 is set for a plea. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Boudreaux.
We're ready, Judge.
All right. Sir, is your name Jacob Kyle Boudreaux?
Yes, Your Honor.
And are you the same person that was originally indicted by Henderson County Grand Jury in this 0594 case of the first degree felony offense of manufacture or delivery of a controlled substance?
Yes, Your Honor.
If I can get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
You can lower your hand. Mr. Boudreaux, can you read and write the English language?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, Your Honor.
And Mr. Boudreaux, have you ever been treated for any mental health or emotional issues?
No, Your Honor.
Do you understand what's going on in here today?
Yes, Your Honor.
And Mr. Weiner, do you believe your client is competent?
I do, Judge.
The court finds he is competent. Mr. Boudreaux, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud in the courtroom?
No, Your Honor.
Do you understand the charge?
Yes, Your Honor.
Well, as indicted, that charge is a first-degree felony. A first-degree felony carries a punishment range of not less than 5 or more than 99 years or life in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand that range?
Yes, Your Honor.
However, it's my understanding that you had this deal worked out with the state whereby you would plead to the lesser included offense of possession of a controlled substance, which is a second-degree felony, and that carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand both those ranges of
Yes, Your
punishment
Honor.
in the plea bargain?
Your Honor, it's 7 years. He has 286 days credit. He's getting a fine of $500. Court costs of $365, $180 lab fee. And we're considering the other case.
Is that your understanding of the plea bargain, Mr. Boudreaux?
Yes, Your Honor.
Is that your understanding, Mr. Weiner?
Yes, Your Honor.
Mr. Boudreaux, a few minutes ago, you told me you could read and write the English language. I'm going to show you two documents. The first is the agreed plea recommendation. Did you read and go over both front and back with Mr. Weiner?
Yes, Your Honor.
And did you sign that?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those documents or both pages of that document with Mr. Weiner?
Yes, Your Honor.
And did you sign that second page?
Yes, Your Honor.
Do you have any questions about it?
No, Your Honor.
Do you have any questions about any of the documents you read and went over with Mr. Weiner?
No, Your Honor.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, Your Honor.
Do you want to do this plea bargain?
Yes, Your Honor.
And I'll ask you, sir, how do you plead to the lesser included offense of that which is charged in the indictment, the second degree possession of a controlled substance? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
I'll hear the evidence.
Your Honor, state author states 1, which is a copy of the offense report, states 2, which is a copy of the case submittal inventory report, and states 3, which is a supplemental case inventory report.
We've previously received, reviewed, and have no objection to any of the state's offers, Judge.
Admitted.
And state rest and closes.
We rest and close as well, Judge.
All right, then, Mr. Boudreaux, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included second degree felony of possession of a controlled substance. The court will follow the plea bargain in sentencing you considers CR 20-0085-173, sentences you to 7 years in the Texas Department of Criminal Justice with credit for 286 days as of today, and orders you to pay your fine and court costs and lab fee. Mr. Boudreaux, just a few more things. Did you have an opportunity to go over the judgment of conviction in your case?
Yes, Your Honor.
Was your name, the charge, and the time credit correct?
Yes, Your Honor.
All right, sir. And now that you have been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. You're now remanded back to the custody of the sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, sir. You can see Mr. Halbert before you leave. To your right. Got Ronnie daydreaming over there. Yep.
I'm going to get that waiver of jury trial signed.
Okay.
Ms. Curry is appearing via Zoom, so can we maybe do the plea today and then get it to her to sign and then maybe follow?
On the waiver of jury, if she consents, and she can just back it up with a signature later.
Fantastic. Thanks, Judge.
Mr. Head.
Milton Kennedy.
Kennedy Milton or Milton Kennedy?
I'm sorry, Your Honor.
So I want to make sure I got it right.
Kennedy Milton.
And that's a plea?
Yes, sir. But, and I'm sorry, Your Honor, it's going to be a PTI, so we have.
Gotcha.
and He's got the packet.
All right, this is cause number CR 20-0455-173, State of Texas versus Kennedy Milton, set for a plea today. Is the state ready?
We're ready, Your Honor.
All right, on behalf of Mr. Milton.
Your Honor, we're ready to present a waiver of jury trial. We have a PTI packet that we are completing. There were some co-defendants that have all received various PTI agreements, and we're just working out the
Gotcha.
details of his.
All right, and so do you have that to present to me?
I do, Your Honor.
All right, I'm going to have to place him under oath, ask him some questions about it. Mr. Milton, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Mr. Milton, I'm just going to ask you about this document and nothing else. I'm holding in my hand this waiver of jury. Did you see this document before?
Yes, sir.
Have you gone over it with Mr. Head?
Yes, sir.
And did you sign it?
Yes, sir.
Did you understand what you're signing?
Yes, sir.
Well, I'm sure that Mr. Head explained to you that both the U.S. Constitution and the Texas Constitution guarantees you a right to trial by jury. You understand that? And no one can take that away from you. Not Mr. Head, not me, and not the state. Do you understand that? However, if you waive this jury and the state consents and I approve, you would, and then something happens and this PTI falls through, or you don't hold up your end of the deal, you would not be entitled to a jury trial. Do you understand that? And you'd still be entitled to a trial before the court with the same constitutional rights that you had before, but you wouldn't have that right to a jury trial. Do you understand that? And do you want to continue to enter into this waiver? And Mr. Head, do you believe your client has entered into this waiver knowingly, intelligently, and voluntarily?
I do, Your Honor.
The court finds that he has, further finds that the state has consented to it and approves it this the 10th day of June, 2021.
Thank you, Your Honor. And if we could maybe get that like a reset for, do you want us to do a reset for
I
July?
don't need one
or
unless
just-
something happens.
I'm okay with that. Doing one way.
Okay.
Okay.
Great.
All right,
Okay,
thank you all. Mr. Weiner. Hagan Poindexter. This is Ms. Curry again.
It is. She's on Zoom.
All right, Ms. Curry, I think we're ready.
All right, Judge.
All right, I'll recall CR 20-0457-173, the state of Texas versus Hagan Poindexter, and this is set for a plea. It's my understanding that he has executed a waiver of jury. Is that correct?
That's correct,
Do
Judge.
you have it?
I'll tender it to you.
Okay. All right, Mr. Poindexter, I'm going to place you under oath, and I'm only going to ask you some questions about this document, okay? If you'll raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God? You can lower your hand. Mr. Poindexter, I'm going to show you this waiver of jury document. Have you seen this before?
Yes, sir.
And did you go over it with Mr. Weiner?
Yes, sir.
All right, well, I'm sure that, and did you sign it there? Is that your signature?
Yes, sir.
Well, I'm sure that Mr. Weiner explained to you that both the U.S. and Texas constitutions guarantee you a right to trial by jury in this case. Do you understand that?
Yes, sir.
And no one can take that right away from you. Do you understand that?
Yes, sir.
Not your lawyer, not me, and not the state. You understand that?
Yes, sir.
All right. And I don't know what deal you have worked out, but you have this deal worked out with the state. And if something happens and it falls through and I sign this, then you would still have other constitutional rights and a right to a trial, but that trial would be before the court and not a jury. Do you understand that?
Yes, sir.
So what I'm getting at is if this all falls apart and I approve this, you'll have a right to a trial, but just before the court.
Yes, sir.
All right, and do you want to do this?
Yes, sir.
All right. And Mr. Weiner, do you believe that he's entered into this waiver knowingly, intelligently, and voluntarily?
I do, Judge.
And Ms. Curry, just for the record, you are appearing via Zoom as a DA pro tem. And are you consenting to Mr. Poindexter's waiver for the state?
Yes, Your Honor.
All right, when the court finds that the state has consented and is approving it, this the 10th day of June, 2021. And do we need a reset?
I don't believe so.
Okay.
I talked to Ms. Curry that we basically put a ticker on our calendars. It's a 6-month non-reporting and that we check back.
Right.
But I will get you to sign the PTI. Thank you.
If it's already done, I'll go ahead and sign it.
It is, Judge.
And then I am signing the pretrial intervention contract.
And then he also signed a stipulation of evidence, which was notarized, and asked you to sign that as well. And then I don't think we'll have any issues, but if we do, we'll contact the court.
All right, I've signed and approved the stipulation of evidence as well as the pretrial intervention contract. Good luck to you, Mr. Poindexter. Yes, sir.
Good day.
All right, Ms. Curry, appreciate you hanging out with us.
You bet. Thank you.
Thanks, Tony.
I'll be up in her neck of the woods in just a little while. Oh, Ryan's gonna fly tonight. No, he does next Thursday.
Okay.
He flies tonight and it's the last one, and then Thursday he flies back.
I'm nervous for you. So that's Sarah Conley, page 7.
Sarah Conley, let's try this again. All right, this is cause number CR 21-0038-173, State of Texas versus Sarah Arden Connolly. And this is set for a plea today. Is the state ready?
We're ready, Your Honor.
And on behalf of Ms. Connolly.
We're ready, Judge.
All right, ma'am, is your name Sarah Arden Connolly? And are you the same person that was originally indicted by Henderson County Grand Jury for the third-degree felony offense of assault of a public servant? Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Ms. Connolly, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Ms. Connolly, have you ever been treated for any mental health or emotional issues?
Yes.
And what would those be?
I'm diagnosed. I've just taken mental health assessments. I've done psychological evaluations. I have a CPS case as well.
Okay.
So,
She's been successfully working her CPS plan
Yes,
for years.
that's about it.
She'll get her kids back next week.
So you got a monitored return coming next week?
Yes.
Congratulations.
Thank you.
All right, and so do you understand what's going on in here today? Mr. Weiner, do you believe your client is competent?
I do, Judge.
The court finds that she is competent. Ms. Connolly, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge? Well, as indicted, that charge is a third-degree felony, which carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
In the plea bargain?
Your Honor, we're asking the court to defer time of guilt, place defendant on probation for 4 years. She has 5 days credit for the sentence, $6,000 fine, attorney's fees, court costs, all the regular terms and conditions of probation apply, including 4 days in Henderson County Jail as a condition of probation. And Judge, there is a confinement order there for the court.
All right, is that your understanding of the plea bargain, Ms. Connolly?
Yes.
Is that your understanding, Mr. Weiner?
It is, Judge.
Well, Ms. Connolly, a few minutes ago, you told me you could read and write the English language. Got 2 documents I'm going to go over with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Weiner?
Yes.
And did you sign the front and the back?
Yes.
Do you have any questions about it? The next document I'm going to refer you to and show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both of those pages of that document?
Yes, sir.
And did you sign that second page?
Yes.
Do you have any questions about it? Do you have any questions about any of the documents you read and went over with Mr. Weiner?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No.
You want to waive that right and do this plea bargain?
Yes.
Then I'll ask you, ma'am, how do you plead to that third-degree felony offense of assault of a public servant as alleged in the indictment? Guilty? And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Judge, I have states 1, an offense report, and states 2 is my memorial compliance.
We previously received, reviewed, and have no objection to state's offers.
Admitted.
State rest.
Yes, as well, Judge. We close.
And just for the record,
Drinking and police normally don't mix.
I'm sure the court was going to ask.
I was just getting ready to ask you.
Yes, I exchanged emails with Deputy Schumate a couple months ago. He's fine with this plea deal.
Okay. All right, well then, Ms. Connolly, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding. Considers that unfiled misdemeanor resisting arrest case places you on, follows the plea bargain, if I didn't say so already, places you on 4 years community supervision with credit for 5 days as to any sentence you may have to eventually serve. Orders you to pay your fine, attorney's fees, court costs, and abide by all the regular and special terms and conditions of community supervision, including this 4 days in the Henderson County Jail as a condition of that probation. And Ms. Connolly, have you ever been on probation?
No.
All right. And have you ever been in any trouble before this?
PIs.
Alcohol.
Alcohol.
Alcohol and police don't mix. Always remember that. All right. Well, Ms. Connolly, do you know what can happen to you if you violate any term or condition?
I do.
What can happen?
I can get a maximum sentence.
That's right. That's kind of the downside of a deferred. Here's what can happen. If you violate even one term or condition, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court. And if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation or find you guilty, revoke your probation and sentence you up to 10 years in prison. You understand that? And it's kind of a dumb reason to go to prison for drinking, isn't it? But people go to prison every day for it. So if you have an alcohol problem, get help.
I'm 9 months sober.
That's awesome. All right. Well, you need to see probation before you leave. Good luck to you.
All right, thank you so much.
Yes, ma'am.
That is all I have. May I be excused?
Yes, sir. Let's see.
It's been a long 2 days.
It has. Well,
Tell me.
we had to cram it in because I'll be out of town for you guys. I'm heading straight from here to the airport and heading straight from there to Irving.
We'll have a good time.
And baseball. It's really pressure now. It's not fun anymore.
Yeah.
Showcases. Yeah.
Where is it?
We're in like 4 different places, DBU, LD Bell, somewhere up in the colony, and somewhere else. I can't remember.
You go to the airport?
Brian flies to Wills Point Airport, and then I'm headed. So I said I'd be up in ran to the free state of Van Zandt.
Is it that one off 19?
64.
64, yeah.
Yep. Good times. Good luck.
Thanks. Thank you.
Mr. Harrington.
Yes, sir. Sam Osmond, page 4.
All right, this is cause number CR 20-0634-173, the state of Texas versus Sam Osborne, set for status. Where are we at?
Judge, we've reached an agreement. We have a signed waiver of jury to present to the court and ask that we get a setting for a plea. That's correct.
Do you need this drug test? And is it,
It's not contingent on the drug test, no, sir.
so y'all have it worked out and it's not contingent? So in other words, if I send him and he tested positive, it's not going to mess up your plea deal.
Correct.
All right. Did I call it? It's been such a long 2 days. I don't even know if I called it. All right, well, let's handle the waiver of jury first. Mr. Osborne, I'm going to place you under oath just to ask you some questions about this document, okay? If I can get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. Osborne, I'm going to show you this document, this waiver of jury. Do you recognize it?
Yes, sir.
And did you sign it?
Yes, sir.
And I'm sure that when Mr. Harrington went over this with you, he told you that you have a right under both the US and Texas constitutions to a trial by jury. Do you understand that?
Yes, sir.
And nobody can take that away from you, not Mr. Harrington, not me, and not the state. You're the only person that can waive that right. Do you understand that?
Yes, sir.
And if I approve this and something happens and your deal with the state falls through, then you could basically, you'd still have many constitutional rights, but just a trial by jury would not be one of them. Do you understand that?
Yes, sir.
So if it fell through, you'd have that right to trial, but it'd be by the court. Do you want to continue to do this today?
Yes, sir.
All right, and Mr. Harrington, do you believe your client has entered into this waiver knowingly, intelligently, and voluntarily?
I do, Your Honor.
That when the court finds that he has, further finds that the state has consented and approves this the 10th day of June, 2021. Do I need another setting?
Yes, Judge.
All right, I'm going to set this for a plea
Yes, sir.
on July 15th at 1:30. All right, so remember any conditions of bond you're on, Mr. Osborne, and I'll see you on July 15th at 1:30. All right, thank you. Yes, sir. We got somebody that's gonna need a ride. Remember? Savian Preston Taylor.
Yes.
All right, Savian Preston Taylor. All right, cause number CR 19-0633-173, the state of Texas versus Sabian Preston Taylor. Is there a Sabian Preston Taylor in the courtroom? I see no one. I hear no answer. There is not a Sabian Preston Taylor appearing via Zoom. He is not in the lobby. The time is now 2:41. The docket was for 1:30. The court will entertain a motion.
State moves for bond forfeiture.
Granted a KPSA issue, he'll be held with no bond. And I would say I'm here all day, but I'm only here for a little while more. So. Anything else?
I don't think so. No. How much longer do you think around today?
I'm gonna be here actually for a while.
Okay.
I understand it was in around here, but it's not here.
And do you have another one?
No, sir, that's it.
Okay. All right. We have Kenneth Bone. His attorney was Bill.
Yes, sir. I'm here, Judge. Can you see me and hear me?
I got you now.
All right, sir.
All right. This is cause number CR 20 or cause numbers CR 20-0017 and CR 20-0690-173, both styled the state of Texas versus Kenneth Bone. Earlier, Mr. Bone was ordered to take a drug test. He's taken that test and he has tested positive for methamphetamine. And I'll note that back in March 29th, he tested positive and admitted to smoking meth on March 23rd. And apparently he was denied, said he was around relatives 2 days ago that used meth. Well, Mr. Bone, I'm going to find your bond insufficient. What's his bond at now?
CR 20-0690-173.
All right, well, then the court is finding both bonds insufficient. The 0017 case, that bond is now set at $50,000 surety bond. And on the 690 case, the bond is now $50,000 surety instead of personal bond. So Mr. Bone, have a seat in the jury box. Bill, you got anything else? Any others waiting for a test?
No, sir, I don't think so. I think that's it.
All right, I appreciate you checking in with us.
Yes, sir. Thank you, Judge. Have a good evening.
Yes, sir. You too. Yes, sir.
This is a standing piece of paper from this morning,
I thought you meant like outstanding.
like really special.
Really
Yeah.
nice one.
Thanks.
There you go, Sandy. He's giving you some late paperwork to make you have to dig through some stuff. So that leaves us with. Where's Jonathan White? How about Jonathan White? What are we doing with that case? Okay. Who was her turn? That was Ms. Fallhaber as well. Yes, sir. Actually, we went through that quicker than I thought we would. We didn't start off going real fast. Right off the sheet, we But I don't know how it do what it do. Sorry, Kevin, Kenny got me. I'd have been out a minute ago, but I was signing warrants. It's like they know when I'm stepping off the bench. All right, you ready? Miss Fallhaber, come on up. Who you got?
Start with Kenesha Miles, please.
Miss Miles, come on up. How about Miss Brown?
Okay. You wanna start with Ms. Brown?
Oh, the UA was diluted. Okay, no, we can't do that yet. All right. All right, this is cause number CR 21-0388-173, the state of Texas versus Kenesha Miles. This was set earlier today, I believe, for a setting this morning, and she did not show. Her name was called. She wasn't present, so the court forfeited her bond and issued a capias and her be held on no bond. However, and the court appreciates the effort it took to get Miss Miles here. And so, Miss Miles, you should be thankful for the effort that these folks put in to get you here. So I'm going to recall the capias. Is there any objection?
No, Your Honor.
All right. All right. And so, ma'am, a plea has been presented to the court now. Is the state ready? And on behalf of Miss Miles.
Ready, Your Honor.
All right, ma'am, is your name Kenesha Shante Miles? And are you the same person that was indicted by Henderson County Grand Jury for this state jail felony offense of possession of a controlled substance? I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Miss Miles, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Miss Miles, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what would those be?
PTSD, depression, personality disorder.
Okay, are you on any medication for that?
No, not really, sir.
Do you need to be?
Maybe reevaluated.
Okay, but do you understand what's going on in here today?
Yes, I do understand.
Okay, and Ms. Fallhaber, do you believe your client is competent?
She hasn't said anything to make me believe otherwise.
Okay, well, Ms. Miles, the law presumes you're competent, even though you've told me you've had these issues. Based upon your demeanor, your answers to my questions, and your statements from your attorney, I find no reason to believe you're not competent and find you competent. Ms. Miles, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
You understand what you're
Oh,
doing?
yes, I understand.
You don't need a word, do you?
And, well, that charge is a state jail felony, which carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
And Mr. Cox, the plea bargain?
Your Honor, 24 months confinement in a state jail felony facility probated for 3 years with a $10 days credit. There's a $2,500 fine, attorney's fees, court costs, lab restitution, and all the regular terms and conditions of probation.
Your understanding of the plea bargain, Ms. Miles?
Yes, sir.
Is that your understanding, Ms. Fallhaber?
It is.
Well, Ms. Miles, a few minutes ago, you told me you could read and write the English language. I'm going to show you this document, this agreed plea recommendation. Did you read and go over both the front and the back of Ms. Fallhaber?
Yes, sir.
Do you have any questions about it?
No, sir.
And did you sign them?
Yes, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you read and went over with Ms. Fallhaber?
No, sir.
Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
Do you want to enter into this plea bargain?
Yes.
And I'll ask you, ma'am, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty?
Yes,
Okay. And are you pleading guilty because you are and for no other reason?
yes,
I hear the evidence.
Judge, I have stage one, non-offense report. Stage two is my more compliance, and stage three is a lab report.
No objection.
Admitted.
State rest.
Rest.
All right, Ms. Miles, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense as alleged in the indictment. The court follows the plea bargain, sentences you to 24 months in state jail. However, the court will probate that, places you on community supervision for 3 years. You do have 10 days credit as to any sentence you may eventually have to serve and orders you to pay your fine, attorney's fees, court costs, lab fee, and to abide by all the regular and special terms and conditions of community supervision. Ms. Miles, have you ever been on probation?
no, sir.
Well, there's a lot of things you have to do and a few things you can't do while on there. Do you know what can happen to you if you violate the term or condition?
Yes, sir.
What can happen?
Get my sentence.
You can go to jail for up to 2 years in state jail. And do you know how state jail is served? Generally day per day. So if you get 2 years, generally you do 2 years. Here's what can happen. If you violate even one term or condition, a motion could be filed, you'd be arrested, a warrant would issue, you'd be arrested, held without bail, brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you to 2 years in state jail. Do you understand that?
Yes, sir.
So would you agree with me? It's extremely important you abide by these.
Yes, sir.
I hope you do, ma'am. And now that you've been convicted of this felony offense, you're now under Texas law and eligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. You need to see Mr. Halbert and probation before you leave. So who do we got next? Mr. White, come on up. Mr. White been here all day long waiting for this, all afternoon. Two cases, huh? Give me just a minute. Appreciate the way you total these for me. That way I don't have to do math. I wish everybody would. Yes, I used to be able to do math in my head really well until I went to law school. Now it's,
Well, it's my pleasure, and I think I actually started doing that at your request.
yeah, because it just helps, especially if there's a bunch on there and I'm up here trying to carry the one.
Yep. We don't know. Right it is.
All right, these are cause numbers CR 20-0640 -173 and CR 20-0639-173, both filed the state of Texas versus Jonathan Ray White, and both set for status today. However, pleas have been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. White,
Ready.
sir, is your name Jonathan Ray White?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for this PCS charge, for the state jail charge of PCS in 0640, and for this third-degree felony charge of evading arrest in 0639?
Yes, sir.
I need you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. White, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into these plea bargains, it can have certain negative immigration consequences. Do you understand that?
Yes, Your Honor.
And Mr. White, have you ever been treated for any mental health or emotional issues?
No, Your Honor.
Do you understand what's going on in here?
Yes, Your Honor.
And Ms. Fallhaber, do you believe your client is competent?
I do, Your Honor.
The court finds that she is, or he is, sorry. Mr. White, I know that we've arraigned you on each of these cases. However, would you like the prosecutor to read the indictments out loud in the courtroom?
No, Your Honor.
But do you understand the charges?
Yes, Your Honor.
Well, as indicted, the state jail felony carries a punishment range of not less than 180 days, no more than 2 years in a state jail felony facility, and a fine not to exceed $10,000. You understand that range of punishment?
Yes, Your Honor.
However, in that 0640 case, it's my understanding that in exchange for your guilty plea, the state is willing to ask the court to convict you as a state jail, yet punish you as a Class A misdemeanor, which carries a punishment range of up to 1 year in the county jail and a fine up to $4,000. Do you understand that punishment range?
Yes, Your Honor.
Now, in this evading arrest case in 0639, that is a third-degree felony, which carries a punishment range of not less than 2 nor more than 10 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand all those range of punishments in both these cases?
Yes, Your Honor.
In the plea bargains?
Your Honor, in CR 2639, we're asking the court to defer a finding of guilt and place the defendant on probation for 7 years. He has 11 days time credit. He's responsible for court costs in this case and all regular terms and conditions of probation. In CR 2640, we're asking the court to, I know it's deferred. What's it reflected on the?
0640 is 11 days with credit for 11 days.
Yes, that's, I'm sorry, Judge, it is correct on here. 11 days confinement credit for 11 days, attorney's fees, court costs. Yeah, sorry.
It's okay. It's a long 2 days. All right, Mr. White, is that your understanding of both of these plea bargains?
Yes, Your Honor.
And Ms. Fallhaber, is that your understanding?
It is.
Well, Mr. White, a few minutes ago, you told me you could read and write the English language. I'm going to show you the agreed plea recommendation from each of the cases. Did you go over on each of these, both pages of that document?
Yes, Your Honor.
And did you sign both the front and the back?
Yes, Your
Do
Honor.
you have any questions?
No, Your Honor.
The next document I'm going to show you, and there's one for each case. I'm only showing you one, but they both say the same thing. The only difference is the cause number at the top. Did you read and go over both pages of that document and sign the second page for each case?
Yes, Your Honor.
And do you have any questions about it?
No, Your Honor.
And that, for the record, is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, Mr. White, if you read and went over these documents with Ms. Fallhaber, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, Your Honor.
Do you want to enter into these plea bargains?
Yes, Your Honor.
And I forgot to ask you, do you have any questions about any of the documents you signed and went over?
No, Your Honor.
All right, well, then I'll ask you, sir, how do you plead in 06, in that CR 20-0639-173 to that third-degree felony offense of evading arrest? Are you guilty or not guilty? And are you pleading guilty because you are and for no other reason?
Yes, Your Honor.
Now, in cause number CR 20-0640-173 to that state jail felony offense of possession of a controlled substance, convicted but punished as a state jail, but punished as a Class A misdemeanor. Are you guilty or not guilty?
Yes, Your Honor.
Are you guilty or not guilty?
Yes, yes, Your Honor.
Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
I hear the evidence in each case.
Judge, before I offer my evidence, it's not on my plea sheet. I wanted to make sure on the 0639, the fine is reflected on there.
It is.
Okay.
No, it's not. There's no fine in here.
Okay, we had agreed on a $3,000 fine, Judge.
Is that your understanding? And Mr. White, is that your understanding?
Yes, Your Honor.
Okay.
And with that addition, Judge, I've got 3 exhibits. States 1 is an offense report, states 2 is Michael Morton compliance, and states 3 is a lab report.
No objection.
Admitted.
State rests in both causes.
Rest, Your Honor.
All right, Mr. White. In CR 20-0639-173, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making that finding, places you on 7 years of community supervision. You do have 11 days credit as to any sentence you may eventually have to serve and orders you to pay your fine, court cost, and let's see, and court costs. And this case will run concurrent with CR 20-0640-173. I forgot to tell you, and abide by all the regular and special terms and conditions of community supervision. Now, in that 0640 case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense, but punishes you under 1244A of our penal code to 11 days in the Henderson County Jail with credit for 11 days and orders you to pay your attorney's fees, court costs, and lab fee. And this case will run concurrent with CR 20-0639-173. And Mr. White, in this 0640 case, now that you've been finally convicted of the felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. And in that case, have you had an opportunity to review the judgment? Was your name, the charge, and the time credit correct? All right, sir. And then finally, in this 0639 case, this deferred, have you ever been on probation? If you have not, well, there's lots of things you have to do and a few things you can't do while on probation. Do you know what can happen to you if you violate this probation? What can happen? That's right. You can, here's what can happen. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be placed in jail without bond, brought back before the court, and if at a hearing, the court found it true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 10 years in prison. You understand that?
Yes, sir.
So would you agree that it's extremely important you abide by these?
Yes, sir.
I hope you do, sir. Good luck to you. You need to see the bailiff, Mr. Halbert, on your way out, and you need to see probation.
Thank you.
You got it.
Miss Brown, come on up. Now, are y'all paying Becker? Are you supplementing her salary out of the DA's office for all this extra work she's doing?
They should.
They absolutely should. I try to spend their seizure money every time I can. All right, this is cause number CR 20 dash. Whose writing is this? 0605? They teach penmanship where you going to school? -173. That's worse than my writing. The state of Texas versus Shanna Brown. Ms. Brown was set earlier today, ordered to take a drug test. Apparently that UA is allegedly diluted. And let's see if I can't read this. And it also states that defendant reported she tested positive for methamphetamine, amphetamine, ecstasy at Nexus. Defendant reported she used meth on 5/30/21, then admitted herself into Nexus on 5/31/21. Refused to sign it. That's okay. And so is she, Ms. Fallhaber, is she in Nexus now? Bless you. Sorry.
She said that she left Nexus so that she would be able to make it to court.
I know you're not in Nexus now, like actually, but are you? Yes, ma'am.
No.
Well, can I see the docket sheet? Tested positive back in May the 11th. And admitted to smoking meth on May 9th. And then I placed her on conditions of bond, and she's admitted that she used on 5/30. And so, Ms. Brown, what's her bond at now?
$10,000 on each case.
All right. Are they both drug cases?
Both child endangerment.
All right, well, then the court finds your bond insufficient and doubles the bond. Each bond will be at $20,000 surety bond. You've already admitted to smoking it after I tested you. And so,
You can't go in. But you have to be ready to get in. Like I watched them push somebody at the line
and so I'm finding your bond insufficient, man. I will tell you this, that if you make some arrangements to check into inpatient rehab, then I'll reconsider it and sign an order to let you out. You need help. And if I have to put you in jail to protect you, I will. And that's what I'm doing.
now. I don't have to go to jail. Is that what you're saying?
Go ahead and have a seat. You'll have to arrange it via the jail.
Thank you, Judge. Might be excused.
Yes, ma'am.
State the excuse.
Yes. Why the others? She's state too. So of all the days, what's your daughter's name again? Madison? Yes, Maddie. He told me I'd forget. He jinxed me. Of all the days for you to come, this was the hardest day we've had in a long time, the longest. But you see how easy we all make it? Because we're the A team, right here, the A team.
It's also her second year anniversary.
This is your second year anniversary of working here? Why didn't you say something? Kevin would have got you a nice gift.
Out of my seizure fund money.
Yeah, the DA's office would have got you a nice gift out of the seizure fund. Well, congrats. 2. Have you been in here 2 years? Okay.
So now you know why she comes home, somebody go on.
I'll be close.
We got this. Freaking backseat drivers.
I don't know how you do it. And hold on, let me mute this.